My lord, may I be allowed to mention a contempt application? Well, there is urgency. My lord, the matter pertains to a unauthorized construction. The order was passed. The demolition order was passed in 2023. More than 2 years, it has not been implemented. Due to the unauthorized construction, the whole locality is waterlogged. Now the urgency is the petitioner got admitted in the hospital this 18th or 19th of June. For her to take us to the hospital, we couldn't let the ambulance enter the place due to the waterlogging. Palat kindly fixes the matter today at any time. I'll make sure to bring the other side.
Very well. Bring your other side, then mention.
Lady, I have your lordships to mention a matter. This is my lord, application for extradition appeared as item number 412. Yesterday, Mr. Shanal mentioned the matter.
Bring your other side.
Ladyship, may I be permitted?
2 o'clock. After regular matters are taken up, I'll take up the applications from 2. After the regular listed matters are taken up, bring your other side. It can be taken up.
Item
Ladyship, may I be permitted to mention item 1275 of the monthly list for upgradation? Ladyship,
No.
My lord,
Mention.
As per your lordship's prior order in a pending matter, my lords, the affidavits have been exchanged and we were given liberty to mention the matter for final hearing, my lords.
Final hearing mention somewhere else, not before this bench.
my lord, I mentioned.
The lordships were hearing the matter, my lords.
Yes, but right now there is no scope to take up hearing matters.
My lords, in that event, may I just pray for an indulgence, my lord? Sir, subsequent developments have happened in the matter for which we have filed a CAN application, my lord. My lords, can the CAN application be taken up?
Can be a can
My lord,
appear.
I'm mentioning for the correction.
But then not today.
My lords,
Application when I take up matters for inclusion, then mention. Not today.
my lords,
Do not give any matters for inclusion.
this contempt, your lordship
My lord,
passed on 11th.
Yes. Contempt when inclusions are taken up, please mention. Not today.
My lord,
Mention very urgent matter, my lord. The bank has already issued a notice for vacating and to take possession, my lord. I have challenged that order of the bank, my lord. If it was,
Surfacey.
yes, my lord, surface matter. Your lordship kindly permits me to move next week any day, any day. I shall give a notice and come back again.
I am granting permission to move the tribunal any day.
Lordship, kindly. I tell your lordship why the tribunal will not be in session over the matter, my lord. I have challenged the order passed by the bank, wherein the bank has directed me to vacate the property and to take away my the properties and all those things. My lord, what the bank has done, my lord, the bank has committed.
Do not say anything now. We are in the mentioning stage. The
my lord, I'm mentioning for the correction.
Tribunal stage is over, my lord. Tribunal stage is over. Your lordship kindly allow.
If you have been illegally dispossessed, tribunal can put you back in possession.
No, my
Right.
lord. I'm still in possession, not illegally, not yet ousted, my lord.
So it's
They have-
right time to approach the tribunal.
Well, I cannot approach the tribunal because tribunal has passed an order which is totally illegal. And even the bank has committed fraud upon the tribunal also, which I will show to your lordship, which will be apparent. My properties of 4 kata, the bank has sold the
Do
property.
not mention the merits. The court is not going on merits of the matter. Right? Thing is whether to grant you leave or not. It is better you file it in the department.
Very good.
My
Your
lord,
lordship
I'm
may be
mentioning for
permitted
the
to-
correction.
After fighting my lord.
File
Your lordship, may I be permitted to mention a matter, your lordship? Your lordship,
for what?
lordship, this is a contempt matter, lord,
For what are you mentioning?
for upgradation, lordship.
Sorry.
My lord, I'm mentioning for the correction, my lord.
What is the correction?
My lord, a clerical error has been crept in as per the order given by you in the monthly list of item number 149, my lord. From my lord, Chief Judicial Magistrate Barasa, it should be additional Chief Judicial.
Very well.
Lordship, the petition.
Stay in your list. I'm praying for 5 minutes, just 5 minutes of hearing. It is urgent.
Sorry, madam. Yes.
Monthly list of 578.
Why?
This is pending for more than 6 years.
Sorry, I'm not listening.
Lordship, item.
Issued on 1st July. We want for
Yes.
on 1st July, my lord. No notice of tender has been issued, my lord. This is relating to the my lord, district hospital, Vishnupur, my lord. And my lord, if this matter is not being taken, my lord, in between 30th, my lord, then my lord, the entire petition will be infructuous, my lord.
Nothing will become infructuous. Please wait.
Lordship, may I be permitted to mention one matter for upgradation, lordship? Lordship, kindly listen to the urgent.
My lord, under extreme urgency, my lord, may I mention one matter? It is appearing as item number 238 in today's list. My lord, the difficulties, my lord, I've inquired,
What you want?
my lord, for upgradation, my lord, so that it can be hard, my lord, because there was a direction passed by your lordships. There was an illegal construction of Baram Port.
Is it an application?
Well, contempt application, my lord.
Bring your other side.
Well,
may
there
I-
is the difficulty, my lord. I have inquired from everywhere. I have mailed to the my lord, Pradhan also yesterday, intimating the fact that today it will be mentioned, my lord, but nobody has been assigned, my lord. I do not know who is appearing.
Then please
But I'm
wait.
praying for leave to move this petition on an urgent basis. My lord, my name is not in the list of in the SARSA registry as a guarantor of the loan account. The mortgage deed, the actual title deed, is in my possession. Despite thereof, sale notice has been issued against my property. And if I go to the tribunal, I'll be accepting the jurisdiction. My whole point is the SARFAESI Act has no application because there was no mortgage created.
Yes. File it in the
And
department.
kindly grants me because sale notice has been
You
sale notice has been issued.
meet with you.
And kindly grants me leave so that otherwise it will take some time.
No, you file it in the department and then see, let us see what can be done.
May I mention after filing?
In the list of the cause list of the Monday, lordship.
Monday it will not be possible. There are so many matters. It cannot be done.
We should be the tender
Yes.
floated. My lord, tender was
Tender was floated.
tender has not been floated, my lord. Without floating the tender, the walk order has been issued. my
That means it must be an extension.
No, my lord, no extension, my lord. I shall substantiate, my lord. The existing cook diet supply has already been left. Now, my lord, new has come. Without issuing the tender, my lord, everything has been settled inside the hospital.
All right, first it will appear. Where is the matter?
My lord, that is it's a new motion, my lord.
Oh, new motion, give the number.
But pursuant
Pahla
to,
tarik, urgent motion.
but pursuant to lordship direction, I have served upon also the Pradhan. My lord, difficulty is, my lord, I cannot find out who is appearing in this case, my lord.
Yeah, what is the item number?
My lord, item 238, today's list.
Application.
Contempt application, my lord.
Come after 2 o'clock. Regular matters will be taken up and then come.
My lord.
Call the list.
Great.
Your Lordship, I am for the respondent in this matter. I am led by Mr. Robi Prasad Mukherjee.
But I'm happy for the petitioner, my lord. This I have grateful to your lordship allowing me because of my ill health, my lord. My lord, the payments have been made to me. Last payment was for the GST that has also been made. So there is nothing due now left out.
Very
The
good.
thing is,
Please
my lord,
come.
they have harassed us. Kindly make some observations or something penalty to them.
Please
They
come.
harassed us for a long years.
The grievance of the petitioner has since been redressed by the respondent authorities. Stop. The dues of the petitioner, comma, though belatedly, comma, have been disbursed. Stop. Next. In view of the above, the writ petition stands disposed of. Call the next one.
Item number 2, I'm appearing for the petitioner. Now, this is a matter with regard to original title deed which was
You were there?
Yes, Your Lordship, I appear for respondent before my lord takes up the merits matter on merits, my lord. I have a issue of mentality. I raise the issue because it is against a private bank.
All right.
The respondent kindly see the error of the parties, my lord.
Yes.
Whether this is
Only
amenable to reach jurisdiction or not.
ICICI
And
Bank.
even the dispute which is raised in the writ petition is totally a private dispute, my lord, cannot be subject
Let
matter.
me understand.
this is a dispute with regard to an original title deed which was taken as by way of a mortgage in respect of an employee at that point of time. Loans were sanctioned. There is document evidencing that the particular title deed was taken by the bank in 1999. Thereafter, 1999. Thereafter, in 2001, suit filed wherein there is an admission by the bank that the original title deed is with the bank. My lord, the suit has been dismissed in 2005. Thereafter, I have filed, the petitioner has also filed a suit. Irrespective of that, my lord, there is today, it is an admitted position that there is no outstanding dues. On that light, I am entitled to get the return of the title deed, irrespective of the outcome of the suit, whether I am entitled to damages or not. On that regard, I write to the bank asking for return of the title deeds. The bank has admitted to that position and requested for certain particulars, but I do not have all the particulars as would appear from the very first document which was submitted in
How
99.
is the writ petition
My lord, it is
maintainable?
maintainable because, my lord, I'm supported by, I will be relying on two judgments. One of the particular one of the division bench of our court, wherein such a situation, the officer of the bank was discharging a public duty, and in such circumstances, if they do not return the title after there being issuance of no due certificate or an admission of no dues, my lord, it would fall within the jurisdiction of the writ court.
Under which bank order was passed?
This is against Axis Bank, and my present writ petition is against ICICI Bank. So, my lord, there is firstly, I would be relying on a Supreme Court decision, which is of 2010.
No, don't go to the 10 one. Come to the recent ones.
My lord, this is, my lord, I shall provide a copy within some time. My lord,
I will not take soft
this
copy.
is, if I may indicate from, it's an SCC print. It is reported at 2024 SCC online, Calcutta 6621. My lord, this is Axis Bank versus Indian Cable Net Company Limited and others. Decided by the Chief Justice along with Justice Bhattacharya. My lord, in this matter, it was passed on, the judgment was passed on 10th of July 2024. My lord, I am relying on paragraph 58.
Whatever you are relying upon, please let your learned friend know about it, and she'll also let you know the decisions that she is relying on. We'll take it up for hearing later on. The petitioner prays for certain direction upon the respondent bank. Stop. Learned advocate for the bank raises a preliminary objection with regard to the maintainability of the writ petition. Stop. It has been submitted that ICICI Bank is a private bank and the writ petition against the said bank will not be maintainable. Stop. Paragraph. Learned advocate for the petitioner relies upon certain precedents in his favor. Stop. The parties are directed to come prepared. List for further consideration. 2 weeks. Yes.
Well, I have given both the citations any date convenient to my.
You will also
Yes, madam.
exchange citations. 10th of July.
Because it will be on a very short issue of maintainability. Thereafter,
Praying for short passover because Mr. Supratik Shamul is engaged in court number 26.
Passover will be
Yesterday
difficult.
also not
Yes,
today
I know also.
taken.
Every day it is being adjourned.
But only, my lord, may I say one thing?
Otherwise, I could
But
have
the
prayed
fourth
for
round of
content.
litigations, my lord's pleasure was on 3rd January. But this is a marriage register. My lord, the charge sheet, your lordship has quashed the charge sheet and directed the authority to issue fresh charge sheet. Fresh charge sheet was issued. Reply was given. Then, my lord, departmental proceeding has been initiated. 3rd June, the date. My lord, she again come before your lordship. And she was requested to verify the documents. She did not. She prayed for.
I cannot help.
Lordship,
I'll make it
kindly
not today only.
affidavit in opposition, Lord, I shall file the affidavit in opposition.
I'll make it not today. I cannot come back. Only not today. Come back.
But instead of Monday, Tuesday, Lord, I am not here. Lord,
But then if 3rd is the date of hearing and 3rd July is the date of hearing and the petitioner is to come.
3rd July, since I am here, Lord, I will tell them not 3rd July, instead of 3rd July, any another date. That I am taking responsibility for.
Very well. Inform them. Learned advocate for the petitioner seeks accommodation. Learned advocate representing the respondents prays for fixing up the matter on 3rd July. List on 3rd.
I appear on behalf of the petition.
The matter could not be filed on the day the leave was granted. It went on to the other day. What is it?
Yes, my lord, the difficulty is because the matter could not be filed. What I've been instructed, my lord, because of there is some mishap in the typographical error in the Vakalatnama. My lord, if your lordship be pleased to recollect, this is a matter where your lordship has already passed an order in respect of one particular person who is residing in the condominium. The disputes has already been referred before the competent authority. Now, my lord, there are 8 families under the condominium who are the subscribers under the first board of managers. Now, my lord, say immediately after the order was passed, now this muzzle of the gun has been shifted towards the 7 writ petitions, 5 writ petitioners, and 2 of them are pro forma respondents. I'm only seeking direction in terms of, my lord, the protection.
Where is the other order?
My lord, the other order is at volume 3,
Who is for the state?
page 338. My lord, we have duly served, my lord. My lord, the affidavit of service.
Served. Private respondents is represented.
Your Lordship, I am representing the President
President
Association. Respondent number 3, Your Lordship.
Respondent number 3. My lord.
Respondent number 3 is
Today,
represented.
during the course of
4
the
and
day,
5.
4 and 5 at the same.
All right, you have the same board. And state, let me see. Achhe. AOR has been served.
My lord, the AOR has been served, my lord. My lord, since it's an.
Your Lordship,
Very
they
well.
have not exhausted the alternative remedy.
What is
As
the
per
alternative remedy?
As per the West Bengal Apartment Ownership Act, a grievance redressal forum is being constituted in every apartment association. They have not represented their grievances before that particular committee, and within 3 days, a long-standing dispute which within 3 days of representation directly to the competent authority, they have filed this present writ application, Your Lordship.
All right. Where is the other order?
My lord, page 338. My lord, if I am
Take
permitted to indicate, my lord, this dispute has already been pending adjudication before the CA.
Yes.
The earlier round of litigation.
Any notice given?
My lord,
Period?
notice further notice was given, my lord. It was fixed on July 16th.
16 July.
Now I have been provided, the erstwhile writ petitioner was provided with an opportunity to file a rejoinder, my lord, by
Right.
9th of July.
You want yourself to be
I
tagged.
want these persons to be clubbed along with in that matter, my lord,
Your
because they are
Lordship-
similarly placed, my lord.
Your Lordship, some differences are there. This
Differences, whatever is the differences, go and
they
mention
have
it.
already, already submitted their replies.
340,
338 at volume 3, my lord.
38.
It starts at 338 and my lord,
38.
paragraph 4 in the same order,
Hmm.
your lordship has protected so far as the ingress and egress and the DG set, non-removal of the DG sets in the condominium is concerned of this petition, my lord. I'm similarly placed and I'm only praying benefit of this order to that extent only.
Yes, that can be extended, Your Lordship. They have installed their own DG set.
Please
and
come.
They have installed their own DG set in the common area, Your Lordship, and they have employed a security service, which
The
is
petitioners claim similar relief as granted by the court on 11th June 2025 in WPO 224 of 2024, IA number GS/1/2024 in the matter of Srimati Meeta Doss and another versus State of West Bengal and others, page 338. They can even stop paragraph. The learned advocate for the petitioners submits that the petitioners lie on the same footing as that of Mita Dos and another within brackets Supra. Stop. The petitioners have also approached the
Competent authority.
Special Commissioner and the competent authority under the West Bengal Apartment Ownership Act, 1972, and submits that as the authority authority has been decided to look into the issue, let an opportunity of hearing be granted to the petitioners at the time of hearing. Top paragraph. Learned advocate representing the association raises an objection with regard to the opposes for the association opposes the prayer of the petitioners. Stop. It has been submitted that the petitioners and Srimati Meeta Doss and another within brackets Supra do not lie on the same footing. Stop paragraph. Where is your representation before the authority?
My lord, the recent representations, my lord, they appear from page, my lord, P46, my lord. P46, volume 3. July 3rd, and there are representations of the other persons, including the pro forma respondents.
Your Lordship, some issues of membership is also there, Your Lordship. as per
Raise
the-
all issues over there. Answer. The
They may be
petitioner is
directed to-
already filed a representation before the competent authority, and the same is pending consideration for a considerable period of time. Stop. Paragraph. Without entering into the allegation and counter allegation of the parties, comma, as it appears that the competent authority is already in scene of the matter. Accordingly, the instant writ petition is disposed of by passing similar order as passed in the matter of Srimati Mita Doss and another within bracket Supra on 11th June 2025. Stop. The competent authority is directed to hear the issues raised by the petitioners and decide the same upon giving a reasonable opportunity of hearing to all the necessary parties, including the pro forma respondents, and by passing a reasoned order and communicating the same to all the parties. Till a decision is taken and communicated to all the parties, comma, the association is directed not to disturb the supply of power enjoyed by the private parties and not to obstruct the free egress and ingress. And not to obstruct their free ingress and egress. Their free ingress and egress.
Your Lordship, they may be directed to pay the maintenance charges from this month onwards, Your Lordship, because they are all paid services and they are the defaulters, Your Lordship.
My lord, about the formation of the
There,
BOA.
it was a civil dispute and has been adjudicated by
Page
the Honorable Court
339,
earlier.
paragraph 5, set out. Has any reply been filed by the association in this case also?
So far as Mita Doss was concerned, association already filed.
Here?
Here, my lord, the association has not even passed a direction so far as the present
Alright.
petitioners and the pro forma are concerned.
Very well. Disposed.
My lord, may I
Your Lordship, they may be
indicate one indulgence, my lord, the present situation, so far as your lordship be pleased to indicate that the free ingress and egress and the obstruction should not be there by the association. Now, what is happening, my lord, since there are, for this 8 persons particular, there is a different set of security guards. Now, they have been removed. Now, the difficulty is association is different from rendering services. Now, even a delivery persons with medicines coming, they have been restricted at the entrance gate because the security guards have been instructed not to.
Very well. You raise these issues because the grievance is
Till
that
such time, my lord,
you are not paying the maintenance charges.
I bow down, my lord. My lord, since I am not paying, my lord, my lord, since I am not paying as on date, my lord, till July, there's a separate set of security guards which has never been disturbed. Now, after immediately this order has been passed, that separate set of security guards was rendering service to this petitioners and Mita Doss's family. They have been removed. Now, my lord, I am in such a precarious situation that medicines, food delivery cannot even.
See, everybody is not so ill. In that matter, it was submitted
Look,
that
there are
the
8
petitioner
different
has
15
8 different
15
families.
defaulters.
Everybody is not ill.
Yes.
Let
I'm not
somebody
taking
come
the
and
pretext
collect
of
the
it,
medicines
Only
and
15 defaulters.
whatever,
My lord, my
whatever
submission-
is your grievance, please raise before the.
But they should pay
authority.
the maintenance, Your Lordship. Without paying the maintenance, they will delay the adjudication for a long time.
Call the next matter.
Lord, 5, my lord. Continuous time to file affidavit in opposition, my lord. We require some extension, my lord. Time extension, my lord. To file the affidavit in opposition, my lord. Extension time to file the opposition. We are not. This is the matter, my lord, where the gratuity of a deceased employee during COVID times of Baman Lorry has been denied by Baman Lorry.
Oh,
My lord, from
yes. What happened?
we require some more time, my lord, to file the affidavit in opposition, my lord.
Some more
Give the
time?
instructions as of now, my lord.
Why don't you carry it in appeal and you are proceeding with the review? Ajay, please come. On the prayer of the learned advocate representing the respondent number 2. Time to file the affidavit. Stands extended till
3 weeks.
3 weeks. 18th of July. Reply, if any, within a fortnight thereafter. List upon completion of the aforesaid time period.
Great. But on the last occasion, I have given your lordship a brief overview of the matter. I have also taken your lordships through the various documents which I wanted to rely on. Now, my lord, if I may just briefly indicate the points. My lord, the writ petition, my lord, it challenges an order which is, my lord, at page 25, which I, Lord, showed to your lordship. Lord, the issue is, Lord, the state security staff, they have not open access to the assembly territory. But Lord, central force personnel on duty, they are made to wait outside the gate. Lord, whether this is, Lord, a permissible, Lord, decision of the speaker. Now, Lord, as regards the threat inside the assembly, Lord, my submission was on the last occasion that, Lord, if the precincts of the assembly house is safe for all the MLAs, then, Lord, state security personnel need not be allowed inside the premises. And this is the very fact that, Lord, these security personnel are allowed inside the premises, in the precincts, Lord, that gives a clear, Lord, clearly demonstrate that, Lord, the threat perception is also there inside the premises. And Lord, I had also, my lord, pointed out that this is a protection, my lord, under Article 21. Security is a protection under Article 21. And Lord, I had shown your lordships, my lord, the letter, my lord, which is at page 24 of the writ petition, where, my lord, the incident that happened inside the premises is narrated. And also, my lord, the enhanced threat, which is there, my lord, in the supplementary affidavit, in the application, sorry, dated letter dated 7th February 2025, that also was drawn to your lordship's attention. Now, my lord, the fact
issue has been raised with regard to the scope of judicial review.
So, my lord, I straight away, my lord, come to that first. My lord, there are certain peripheral issues, like, my lord, that whether, my lord, this violates Article 14, this letter, that I will address later. But let me first address your lordship on the question of whether, my lord, judicial review is permissible of an action of a speaker. Lord, Lord, a few provisions of the Constitution, Lord, if your lordships kindly take note of first. First is Article, Lord, 14 and 21, which I don't need to place.
Okay.
Kindly, Lord, come to Article 208.
Yes.
It deals with rules of procedure. Lord, it says a house of legislature or a state may make rules for regulating, subject to the provisions of the Constitution, its procedure, and the conduct of its business. Then it is until rules are made under clause 1, the rules of procedure and standing orders in force immediately before the commencement of this Constitution with respect to legislature for the corresponding province shall have effect in relation to legislature of a state subject to such modification. Here, my lord, the rules of procedure has been, Lord, framed. So, my lord, we are covered under 208(1). This 2 talks about that until the rules are made. So, my lord, this really dependent on 1. If 1 is complied, then obviously. Then, Lord, your lordships may kindly come to Article 212, 212.
Yes.
Article 212, it says, the validity of any proceedings in the legislature of a state shall not be called in question on the ground of any alleged irregularity of procedure. Now, my lord, what is meant by this alleged illegality of procedure, that has been explained in the various judgment of the Supreme Court. I'll place the last one, which has taken note of the earlier judgment, because, my lord, it has been held that judicial review under Article 226 is not ousted by this expression, alleged irregularity of procedure. If there is an encroachment on the rights under Part 3 of the Constitution, that is fundamental right, then, my lord, this would not come in the way. This is 212. And then, Lord, your lordships may also kindly take note of Article 194. It says that subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of the legislature, there shall be freedom of speech in the legislature of every state. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of a house of such a legislature of any report, paper, votes, etc. In other respect, the powers, privileges, and immunities of a house of a legislature of a state and of the members of the committee of a house of such legislature shall be such as may from time to time be defined by the legislature by law, and until so defined shall be those of that house, of its members and committees immediately before the coming into force of Section 26 of the Constitution, 4th Amendment Act, etc. The provisions of 1, 2, 3 shall apply in relation to persons who, by virtue of this Constitution, have the right to speak in and otherwise to take part in proceedings of a house of a legislature, of a state, or any committee thereof, as they apply in relation to members of that legislature. Now, my lord, on account of the rules of procedure, if I may just draw your lordship's attention to few of the rules of the procedure. একটা এরকম বই আছে দেখুন না, যদি থাকে ভালো, না হলে এটা দিয়ে দিতে হবে। এই ফাইলে আছে এরকম? No, otherwise kindly take it.
File, is it there? Did you file it earlier?
Before Justice Sarkar, we had. No, it may have been returned. I can't say for.
It is not there in the
It
file.
was, yes. That doesn't matter. Just Lord, take it.
Yes.
Lord, please come to Rule 352. Lord, I'll rely on, Lord, four, Lord, rules of this rules of procedure. 352 first.
Yes.
The speaker shall preserve order and shall have all powers necessary for the purpose of enforcing his decision. Then, Lord, please come to Rule 360. The admission of strangers during the sittings of the House to those portions of the legislative building which are not reserved for the exclusive use of members shall be regulated in accordance with directions made by the Speaker. It says, my lord, admission of strangers during the sitting of the House to those portions of the legislative building which are not reserved for the exclusive use of members shall be regulated in accordance with directions made by the Speaker. Then, Lord, come to 361. This power is exercisable during the sitting of the House. Then, Lord, please come to 361. The Speaker may, whenever he thinks fit, order the withdrawal of strangers from any part of the legislative building. 361. Then, Lord, kindly also take off note of 364, which is the residuary power. All matters not specifically provided for in these rules and all questions relating to the detailed working of these rules shall be regulated in such manner as the Speaker may from time to time direct. This is the residuary power. Now, my lord, as regards power under 361, this is, my lord, a power given to the Speaker to exercise whenever he thinks fit for withdrawal of strangers from any part of the legislative building. legislative building and precincts, they are defined. If your lordships, my lord, kindly come to, Lord, firstly, 361 has to be applied down the rank. It's not that it is applicable only in respect of some, not applicable in respect of some. If the security agencies are taken as strangers, then Lord,
Is stranger defined?
no, stranger is not defined. If security agencies are treated as strangers, I'm just anticipating the argument. That's why, Lord, I'm putting it before your lordship. If security agencies are taken as strangers, then Lord, it can't be selected strangers. It has to apply across the line. Now, Lord, please take the definition of the rule. First, come to Rule 2. Look, under Rule 2.1, there is a definition of house. Your lordships will find that.
Yes.
Means the West Bengal Legislative Assembly. As your lordship.
Yes, yes.
Then, Lord, please turn the page. Your lordships will find the second from the top, precincts of the house. Means and includes
Yes.
the legislative building and the grounds surrounding it, includes within the iron railing. So, Lord, between the building and Lord, the iron railing, Lord, the entire thing is treated as the precincts. And Lord, the building is, rather the house means the West Bengal Legislative Assembly. Now, Rule 361 talks about legislative building.
Yes.
So, Lord, building has a different meaning and Lord, precincts have a different meaning. Lord, why I say this? Because your lordships may kindly take the affidavit of the state once. I have though placed it just for my satisfaction. If I may just show your lordship the affidavit of the state.
Yes.
Kindly, my lord, come to E. Because, my lord, the use of word strangers, your lordships will find here.
E.
Sorry, page 6. Kindly, my lord, come to page 6. It's paragraph 3E.
Yes.
Your lordships will find the expression strangers here.
Yes, E.
E says admission of non-member strangers during the sitting of the house to those portions of the legislative building which are not reserved for exclusive use of the members are regulated in accordance with the direction made by the Honorable Speaker. And then again, Lord, the legislative building is used. So, Lord, this is 361. Now, Lord, kindly also take the note of paragraph 3G, page 7.
Yes.
I have already placed this note on the last occasion. I'll just repeat it. Likewise, bulletins have also been published by the West Bengal Legislative Assembly. Such bulletins have consistently provided that persons accompanying ministers or members in the cars, buses would have to get down at the respective gates and enter the assembly campus through the southwest gate, gate number 2. Only on production of valid entry pass and frisking. Only one companion with one member would be allowed to enter into the assembly house campus during the session. Furthermore, no security personnel will be allowed to enter with arms inside the main building. So, my lord, security personnel are allowed to enter the main building but without arms. So, this is, my lord, the bulletin which is covered, my lord, in paragraph G. Now, my lord, if your lordships, Lord, I have placed, Lord, the other part. I just, Lord, want to be very brief. Now, Lord, the question today is that, Lord, this action, whether it is prima facie, Lord, violate Article 14. Because, Lord, security is an issue which is covered under Article 21 for all legislatures. Now, Lord, they are permitting the security guards of the legislatures who are provided with state securities, but not providing the same with regard to the central forces. So, my lord, whether this is, my lord, prima facie a violation of Article 14, and my lord, 21, your lordships will see Article 21. This talks about the security. And Lord, there is a judgment which I'll show to your lordships later. I'll first deal with this judicial review point, where, Lord, this is an admitted position, where, Lord, the report of the state was filed saying that this gentleman, his security threat is there. And Lord, that is discussed in earlier judgment. Now, Lord, I straight away, Lord, first deal with this point of judicial review. If your lordships, Lord, kindly take ওই এটা দাও শ্যালটেরটা হ্যাঁ আশিস শ্যালট হ্যাঁ এসেছে প্রিন্ট আউট আছে না না প্রিন্ট আউটটা দাও এখানে এখন তো রিপোর্টেড হয়ে গেছে প্রিন্ট আউট দেওয়া বেটার কারণ জজে পড়তে পারবে হ্যাঁ হ্যাঁ এসসিসিটা দেওয়াই বেটার এসসিসির প্রিন্ট আউট আছে আচ্ছা whatever it is 2022 this is 2022 volume 12 SCC 273. Lord, I'll provide your lordship with a Xerox copy.
Yes.
Lord, kindly take paragraph 1 to 6, which states the fact.
126.
1 to 6, Lord, paragraph 1 to 6.
All right.
Just to Lord, show your lordship. Lord, please take paragraph 1, page, this is 273, it starts.
Yes.
The petitioners have been duly elected as members of the current Maharashtra Legislative Assembly. They got elected from different constituencies in the state of Maharashtra. They belong to Bharatiya Janata Party, the principal opposition party in Maharashtra Legislative Assembly. The ruling party is a coalition between Shiv Sena, etc. The list emanates from the events as unfolded during monsoon session of the Maharashtra Legislative Assembly on 5th July 2021. The proceedings of the House witnessed heated exchange between the members of the opposite party and ruling party due to an impression formed by the former that the business of the House was being conducted in unilateral manner, with conscious and engineered effort to suppress voice of the opposition party. In that event, the leader of opposition was denied an opportunity to speak on the crucial motion under consideration. At the relevant time, the House was presided over by the chairman nominated under such and such. Denied opportunity to the opposition to speak, including the leader of opposition. Then, Lord, kindly, Lord, come to paragraph 3. Your lordships will find that the assembly session was cut short. Your lordships will find that is set, cut short. The concerted effort was strip of all legislative tools available to opposition party. Then, Lord, kindly come to paragraph 4. The chair of the Speaker of the House was vacant at the relevant time due to stepping down by the incumbent. The election of appointing a new Speaker of the Assembly was yet to be conducted. As per Rule 8 of the rules, in such a situation, other nominated member of the House had to preside. As aforesaid, a general feeling had developed amongst the members of the opposition party that the business of the House was not being transacted in congenial manner, and they were prevented from raising important questions and express their views on the matter of public importance. Then, Lord, please come to paragraph 5. Kindly, Lord, just leave about 4 or 5 lines, the sentence starting with the word, when the House resumed. The nominated chairman referred to the fact that some members of the Shiv Sena were present in the chamber and involved in heated exchanges, but no action was being taken against them as both the sections had apologized to each other. According to the petitioners, when the House resumed by way of courtesy, a sincere apology was graciously tendered by the leader of opposition to the chairman for the earlier incident, while adverting to the fact that none of the MLAs belonging to opposite party BJP, including petitioners herein, had abused the chairman. Soon thereafter, to the utter surprise of the petitioners and the members, the Minister for the Parliamentary Affairs moved a resolution for initiating action against 12 MLAs of the BJP for having committed contempt of the House. That motion was tabled in the House, and the chairman was called up to do the needful. The chairman then called upon the House to pass the said resolution. The House in turn passed the said resolution by majority votes, etc. Then, Lord, your lordships will see that they were, Lord, suspended for a period of 1 year. That decision, Lord, is set out in paragraph 6 itself. Towards the end, your lordships will find that the resolution was to suspend, Lord, some of the members of the opposition for a period of 1 year, including the leader of opposition. Now, Lord, this is the reason why, Lord, the matter went to court up to from Bombay High Court. It came to the Supreme Court. Now, your lordships may kindly come to paragraph 12. Lord, your lordships may kindly, Lord, skip the first part. Your lordships will see the sentence starting with the word "as regards suspension of a member of the House." Has your lordship got that? As per Rule 53 of the rules, such action could be initiated only by the Speaker after complying with the principles of natural justice and fair play. The provisions such as Rule 53 is engrafted to put a check on the majoritarian attitude of the government. The Speaker is expected to act fairly, etc. Then, Lord, please come to the next paragraph. It is urged that a motion for unruly behavior in the House can never be subject matter of voting, since it would be enable the political party in power to virtually wipe out the opposition for some trivial acts committed by their members. By suspending as many members of the opposition party, the decision of suspension, therefore, must rest with the Speaker and not House. Notably, Rule 53 of the rules prescribes a maximum period of suspension not exceeding such and such. This is not very important. Your lordships may kindly come to paragraph 23. The moot question, as a lordship, is about the maintainability of the challenge in respect of the stated resolution adopted by the Legislative Assembly. The scope of interference by the court has been well delineated in successive decisions of the Constitution Bench of this court. This court has consistently expounded that the judicial scrutiny regarding exercise of legislative privileges is constricted and cannot be stricto sensu on the touchstone of judicial review as generally understood in other situations. In that, there is a complete immunity from the judicial review in matters of irregularity of procedure. The Constitution Bench of this court in Raja Rampal delineated the principles on the basis of catena of decisions noted in the said decision. Then, Lord, the quoted portion 431, we may summarize the principles that can be culled out from the above discussions. They are: Parliament is a coordinate organ, and its views do deserve defense even while its acts are amenable to judicial scrutiny. The constitutional system of government abhors absolutism, and it being a cardinal principle of our constitution that no one, howsoever lofty, can claim to be the sole judge of the power given under the constitution. Mere coordinate constitutional status or even the status of an exalted constitutional functionaries does not disentitle this court from exercising its jurisdiction of judicial review of actions which partake the character of judicial or quasi-judicial decision. Then, Lord, please come to D. Yes. The judicial review of the matter of exercise of power of contempt of or privilege does not mean the said jurisdiction is being usurped by the judicature. Having regard to the importance of the functions discharged by the legislature under Constitution and the majesty and grandeur of its task, there would always be an initial presumption that the powers, privileges, etc. have been regularly and reasonably exercised, not violating the law or constitutional provisions, this presumption being a rebuttable one. The fact that Parliament is an august body of coordinate constitutional position does not mean that there can be no judicially manageable standard to review exercise of its power. While the area of powers, privileges, and immunities of the legislature being exceptional and extraordinary in its acts, particularly relating to exercise thereof, ought not to be tested on the traditional parameters of judicial review in the same manner as an ordinary administrative action would be tested. And the court would confine itself to the acknowledged parameters of judicial review, and within the judicially discoverable and manageable standard, there is no foundation to the plea that a legislative body cannot be attributed jurisdictional error. Then, Lord, kindly come to paragraph. Kindly, Lord, see, it is, Lord, ABCD in that form. Please come to Q. The rules which the legislature has to make for regulating its procedure and the conduct of its business have to be subject to the provisions of the Constitution. Then, Lord, S, the proceedings which may be tainted on account of substantive or gross illegality or unconstitutionality are not protected from judicial scrutiny. Then U, an outsider, an ouster clause attaching finality to a determination does not ordinarily oust the power of the court to review the decision, but not on the grounds of lack of jurisdiction or it being a nullity for some reason such as gross illegality, irrationality, violation of constitutional mandate, malafide, non-compliance with rules of natural justice, and perversity. Then, Lord, please come to paragraph. Kindly give a moment. Please come to paragraph 29. Paragraph 29. In the Indian context, the power of legislature is not absolute. As noted by the Constitution Bench in Raja Rampal, the same reads thus: we are of the view that the manner of exercise of power or privilege by Parliament is immune from judicial scrutiny only to the extent indicated in Article 122(1). That is to say, the court will decline to interfere if the grievances brought before it restricted to allegation of irregularity or procedure. But in case of gross illegality or violation of constitutional provision is shown, the judicial review will not be inhibited in any manner by Article 122 or for that matter by Article 105. Then, Lord, your Lordships need not bother. Kindly, Lord, come to paragraph 31. Lord, before that, just above that, your Lordships will find there is a quote from paragraph 416, that is from Raja Rampal. Your Lordships will kindly see that. Learned Additional Solicitor General submits that UP Assembly case, the court had placed reliance on Article 208 and 212 with contemplate that rules can be framed by the legislature subject to the provisions of the Constitution, which in turn implies that such rules are compliant with the fundamental right guaranteed by Part 3. He submits that if the rule framed under Article 118, which corresponds to Article 208, are consistent with Part 3 of the Constitution, then the exercise of power, privileges, and immunity is bound to be fair exercise of, and Parliament can be safely attributed such an intention. Then, Lord, paragraph 417, kindly see the last 6 line. It says, we are of the opinion that mere availability of rules is never a guarantee that they have been duly followed. What we are concerned with, given the limits prescribed under Article 122(1), is not irregularity of procedure, but illegalities or unconstitutionalities. And then, Lord, 31, from the exposition of these successive Constitution benches decision referred to above, it is not possible countenance to submission of the learned counsel for the respondent state that inquiry must be limited to one of parameters specified in Raja Rampal, and in this case only clauses, the proceedings which may be tainted on account of substantive or gross illegality or unconstitutionality are not protected from judicial scrutiny. On the other hand, we learn in favor of taking the view that each of the parameters is significant and permissible area of judicial review in relation to exercise of parliamentary privileges, including F, G, S, and U. In one sense, clause U is comprehensive parameter articulated Constitution bench in Raja Rampal. These are, Lord, I placed those paragraph, Lord, ABCD. As it predicates that an ouster clause attaching finality to a determination does ordinarily oust the power of the court to review the decision, but not on the grounds of lack of jurisdiction or it being a nullity for some reason, such as gross illegality, irrationality, violation of constitutional mandate, malafide, etc. The Constitution by itself does not specify the limitation on privileges of the legislature, but indubitably those privileges are subject to the provisions of the Constitution as is predicated in the opening part of 194(1), requiring the House of the Legislature to make rules for regulating its procedure, which ought to include the rights guaranteed to the citizen under Part 3 of the Constitution. The moment it is demonstrated that it is a case of infraction of any of the rights under Part 3 of the Constitution, including ascribable to the Articles 14 and 21 of the Constitution, the exercise of power by the legislature would be rendered unconstitutional. For attracting Article 14 and 21 of the Constitution, it is open to the petitioner to demonstrate that the action of the legislature is manifestly arbitrary. The arbitrariness can be attributed to different aspects. Applying that test, it could be a case of irrationality of the resolution, decision of the House. Indeed, in this case, the court is not called upon to inquire into the proportionality of such a resolution or decision. Now, my lord, the substance, my lord, it goes on further discussion, but the substance, my lord, is that the rules of procedure can't be read bereft of Part 3. It has to be in consonance with Part 3. Therefore, my lord, anywhere the court finds that Part 3 is violated, the court can strike it down, and the judicial court retains its jurisdiction of judicial review. So, my lord, this is in substance what this judgment says. My lord, in fact, all the constitutional bench judgment, Article 212 was set up as a defense. In all these cases, your lordships would find that in all these cases, this is the finding that 212 gives them certain power, but not to denude a citizen, including the legislature, of their protection under Part 3. So this is how, my lord, the matter stands. And, my lord, my contention is, therefore, my lord, the judicial review is open for your lordships to consider. Now, Lord, our division bench has followed this view also. This is, Lord, I'll give a copy to my learned friend. Lord, this is a judgment of our division bench.
Paragraph 29 to 35.
Your lordships may kindly take, my lord, paragraph 29 to 35. I mean, the copy. Paragraph 29 to 35. But in fact, Quixote Holan was the first judgment which is considered in para 29. Then Article 122, 121, these are 122 and 212 is considered. Raja Rampal is considered in para 32. And then, Lord, Rajendra Singh Rana is at paragraph 33. Then, Lord, paragraph 35. 34, Lord, the Srimant, that the other judgment. Thus, it is clear that the decision of Speaker under para 6.1, 10th schedule, is open to judicial review, though it can be questioned only on the limited grounds of malafidis, perversity, violation of constitutional mandate, or violation of natural justice. Hence, the impugned order is required to be scrutinized, keeping in mind the limited grounds of judicial review. In fact, Lord, I didn't trouble your lordship, Lord, starting from that Quixote Holan judgment, this has been a consistent view of the court. This was, Lord, a case of disqualification, Lord. Or defection. Defection and disqualification.
Nomination of the
So, Lord, the short point, therefore, is, Lord, whether this is one such case where, Lord, interference is called for by your lordship. Lord, the fact of the matter is that there was repeated representation that please reconsider your decision, which has been declined. Now, Lord, the question is today that if the legislature of one political party can be safe inside, it can't be said that the legislature of the other political party who are covered by the state security agencies should have their securities inside. So this is, Lord, the short point on which I wanted to address your lordship, and I think due to shortage of time, my lord said that to cut short. My lord, if in reply I need to reply, my lord, kindly permit me. These are my submissions.
So judicial review is over, and more or less your submissions are over.
Are over. If your lordship gives me, my lord, another 10 minutes, my lord, I
Why?
can.
What are the other
No,
issues?
very well. If I need
More or
need
less
to,
you've covered
I
it.
have covered. If I need to reply, my lord, I give a reply. My lord, if any points are raised, I'll give a reply. My lord, I'll cover it.
Points are already there in the opposition.
Opposition. Yes. This is not a opposition points I have dealt with. My lord, I have dealt with the opposition points. Judge sir বলেছেন কম।
Well, more time cannot be given. Enough.
No, no, we were begging for time for Mr. Kaur.
Yes, yes. For him only, for both sides, not for him, it's for all
Is
sides.
always generous towards me.
For all parties.
But not
When
this
would
time
you like
I
to come back?
refuse it.
You know, after next week. Skipping over the next week. কে বিধানসভায় তো বসছে না এখন আবার কি করবে সেটাকে শেষ করতে চাইছে ইলেকশন অবধি টেনে দেবে দিয়ে এই জিনিস করবে
Acha. Learned senior counsel representing the petitioner concludes argument.
তো অন্যগুলোকে বন্ধ করে দে না অন্য লেজিসলেচার যেগুলো ঢুকছে তার বন্ধ করে দে। সবাই একসঙ্গে ওইখানে বাইরে থাকো
একেবারে সোমবারটা ব্লক করবো না আমার 8 তারিখে 8th I'm keeping it Tuesday. List on 8th for hearing the respondents.
কপিটা দিয়ে দে the Xerox copy of it.
All right. This book, will we keep it?
Yes, yes. Kindly keep it with your lordship. হ্যাঁ কপি আছে তোর কাছে এক্সট্রা কপি আছে
একটা কপি দাও না কিশোরদাকে আবার আমাকে দেবতার ঘরে করতে হবে এটা আরেকটা কপি দাও
আমারটা নিয়ে নেন
না না এই দিদা এই দিদা I'm grateful.
No further matters.
But could it be recorded as hard in part?
কারণ এটা সাবস্টেন্সিয়ালি শুনানি হয়ে গেছে এখন যদি আবার
Why? Are you apprehending? See, the moment these type of submissions come, the court also starts thinking.
there are news of two new honorable judges coming. So যদি কোনো হ্যাঁ যদি determination আবার চেঞ্জ হয়ে যায়
But kindly give us some protection, my lord, in case anything of that nature happens.
Not now.
Petition number 1, my lord, I am led by Mr. Siddhartha Banerjee is appearing on virtual mode.
My lord, will kindly, my lord, allow me to appear on the virtual platform. My lord, this is, my lord, for extension of interim order, my lord, lastly extended on 25th of February by your lordship. My lord, the interim order is there till, my lord, 30th of this month.
Is there any requirement of continuing with the interim order?
Yes, my lord, yes. Otherwise, my lord, the entire matter will become infructuous. I just indicate, my lord, what is the matter about. My lord, there is a property, my lord, which is purchased by me. Now, my lord, the district magistrate, my lord, passed an order, my lord, usurping the jurisdiction of civil court, while, my lord, there is a civil suit pending, saying that, my lord, certain registered indentures are bad, my lord, I could not have purchased, my lord, the property and all. My lord, we have challenged, my lord, the jurisdiction and authority, my lord, competence of the magistrate, my lord, saying, my lord, in saying so, because, my lord, a suit is pending at my instance, where, my lord, there is an interim, my lord, protection granted. So, my lord, that cannot be, my lord, overreached, my lord, by the district magistrate. That's, my lord, the short point, my lord, involved here. My lord, Justice Shobboshachi Bhattacharya, my lord, was kind enough, my lord, to pass an interim protection, which your lordship has also, my lord, deemed fit, my lord, to extend on the last occasion.
What is the position of the civil proceeding?
My lord, there is a public interest litigation, my lord, which has been initiated by, my lord, this, my lord, whom, my lord, we call, my lord, a meddlesome interloper. He says that, my lord, this land could not have been purchased by me, but all, my lord, these issues are pending adjudication in, my lord, before a competent forum in a civil suit. My lord, the public interest litigation now, my lord, this gentleman, my lord, has taken out an application which is pending before the Honorable Division Bench. In the interregnum, District Magistrate, my lord, did this. My lord, if the interim order is not there, my lord, all the proceedings would become infructuous, and my lord, I would, my lord, suffer, my lord, despite there being litigations, there being, my lord, interim protection granted.
Please tell me under which provision of law did the district magistrate pass the order?
Well, that is, my lord, possibly for my learned friend, my lord, to answer. I, my lord, presume, my lord, under the public premises, my lord, West Bengal Public Land, my lord, Eviction of Unauthorized Occupants Act. But, my lord, that was not, my lord, in so many words invoked. My lord, there is a procedure, my lord, for invocation of those provisions, which has also not been done. So, my lord, I presume this. My guess is, my lord, absolutely wild.
What is your submission?
My lord, I am for the respondent number 5 and 6, my lord.
Yes.
My lord, we have made the, my lord, application for seeking clarification, my lord.
Before?
Before the, my lord, Chief Justice bench, my lord. Because, my lord, this matter, the public interest
My lord, I
litigation
indicate. My lord, the public interest litigation was initiated. The Honorable Division Bench was pleased to pass an order. My lord, it was in
by
the guise.
virtue of that order, the district magistrate passed an order, my lord.
Correct.
And
Now, my lord, Justice Shobbhashati Bhattacharya was pleased to observe that, my lord, the Honorable Division Bench did not confer, my lord, a jurisdiction on the district magistrate, which law does not confer. So, my lord, in the guise of, my lord, implementation of the Honorable Division Bench's order, my lord, this kind
What
of an order
happened to
could
the
not have been
proceeding
passed.
before the division bench?
Sir, that is not hard yet, my lord. Kindly, my lord, see the order.
Or the interim order that is subsisting in the matter is extended till 12th of December 2025 or until further order, whichever is earlier.
Grateful.
Liberty to mention the matter for hearing.
Grateful.
Grateful, your lordship.
I beg to appear for the petitioner. There was an interim order lastly extended on 24th March 2025. I was praying for extension of the same. My learned friend has filed a modification application where affidavits are complete. Your Honor can fix it next Thursday. It comes up on the list every Thursday. We can hear it. Till that time, the interim order may be extended.
What is the interim order that you are in?
This was with respect to with a challenge the contract of the railways, which had not followed their own circular with respect to Diet North. His Lordship, Her Lordship, Justice Shampa Sharkar had considered every point and passed an interim order on 25th June 2024. But instead of an opposition to the writ petition, they have chosen to take out a CAN application.
See, the Dias non period is long over.
Blood, we have filed an application for modification of verification.
Let that
because
be taken.
The Justice Sampa Sarkar order was subsequently modified. That's time, Lord, I filed an application for modification, but that has not been heard yet today.
No, but thing is, the Dias non period, 68 days or 90 days or how many days, whatever.
That was not calculated or adjudicated in this case.
Now you are enjoying.
I am paying license fees, enhanced license fees as per the demand and operating.
And
they
operating, so that period is long over now.
But they have not adjudicated how much exactly should be there.
CAN application be hard, very.
Let the CAN application be heard. I do not have a difficulty.
Next week.
I do not have a difficulty with that submission.
Same order, I am paying for same order, page 13 of the. Wait. Page 13.
Page 13.
Page 13. CAN application.
Oh, CAN.
1st of August 2024.
Yes.
1st August 24.
1st August. What is that?
You want the writ petition to be disposed of, directing the senior manager to look into the issue.
Yes.
This is what you want.
Yes.
Yes. If
There are
this,
the points in the CAN. Let the CAN be taken up next Thursday. Lordship keeps it on fairly at the top and disposes.
Another matter, your Lordship, is
please
page
wait.
15.
Page 13, do you have?
Yes.
The petitioner, sorry, the applicant wants a direction upon the authority to treat your writ petition as a representation and to dispose it of.
Yes.
Why? This can be passed
That
now,
can be done. That can be done.
and the writ petition can be disposed of.
Only difficulty is kindly then records that all the parameters as per the circular needs to be considered and elaborately done. When a similar matter passed by your order, my apprehension is not unfounded. It has happened similar matter. Your lordship has passed an order, and the authority has just chosen to replicate the same thing without considering any of the subjects.
Another
and
order,
non-recent orders are passed in these kind of matters.
And
another
where is
order also
the-
page 15. Your
Where
lordship.
is the circular or what you want to read?
That is my writ petition.
Wait, give me the page.
Page 15 of another order. Page 15 is another order. কি অবস্থা কালিস দাঁড়ান আমি বলে দিচ্ছি তারপরে
Page 32, page 31 and page 32 of the writ petition.
Yes. It is 21st of August 2020.
That is there. Then page 32, 35.
Please come. Is it a stall or what?
I have stalls and trolleys both.
Trolleys. In this writ petition, the stalls and trolley both are involved?
Yes. Lordship, in fact, I have stall, trolleys, stroke tables. 2 tables in one of the other stations. There are 2 stations involved in writ petition. Kharagpur and Balapur.
अच्छा लिखूं क्या? The writ petition was filed by the petitioner challenging the action taken by the railway authority allegedly contrary to the railway board circular issued from time to time relating to the relief granted to the multipurpose stalls / trolleys. Stop. More particularly, the issue is with regard to calculating the dies non period. Stop. After hearing the after hearing the submission made on behalf of the petitioner, the court passed an interim order on 25th June 2024 by granting liberty to the petitioner, by directing that the petitioner will continue to pay the requisite license fee, GST, and any other fee and charges payable for conducting the business according to the policy of the railway board and in terms of the contract of the petitioner. Stop. The said interim order stood extended from time to time. Paragraph. Admittedly, the contractual period of the petitioner has expired. Stop. The petitioner will, however, be entitled to the relief granted by the railway board. Stop. Paragraph. By virtue of the order passed by the court, the petitioner is continuing the business upon payment of charges. Stop. At this stage, it may not be proper to extend the interim order further. Stop. Next. Accordingly, the court is minded to dispose of the writ petition by passing the following direction. Stop. The Senior Divisional Commercial Manager, Eastern Railway Shialda, is directed to consider the. Do you have a representation or something?
Yes,
It
sir.
was
Where is
now
it?
Southeast Railway, Kharagpur.
Page.
Yeah.
To consider the representation made by the petitioner.
No,
Yeah, that's
not
Chief
Kerala.
Justice versus Kharagpur.
Southeast
Writ
Railway,
petition-
Kharagpur.
Writ petition page number 2 has the detailed address.
Page number?
2 of the writ petition has the address, complete address.
All right, 2 is all right. Where is your representation? একটু দেখে নেবেন তো শিয়ালদা না খড়গপুর আছে বোধহয়।
This will be Kharagpur.
Senior Divisional Commercial Manager, Southeast Railway, Kharagpur.
South Eastern Railway, Kharagpur.
Lordships have been directing this
Respondent
to
number
go as the
4.
representation.
Which
Writ
one?
petition has to be treated as a
Oh, do you have a proper representation in place? Not the red petition.
Respondent number.
It must be there. It must be there in your red petition itself.
I'm just checking. I do not think there is a. No. No. Because there was this, in this matter, there was a termination of the, alleged termination of the contract by passing a direction opposing, contrary to the policies. I can demonstrate that in the writ petition.
All
There
right.
was no representation. We had straight away, we had to come to the writ court to seek protection.
এখানে বললাম না কন্ট্রাক্ট কি বললাম একটা কন্ট্রাক্ট has ended নাকি?
Admittedly, the contractual period of the petitioner has expired.
না, admittedly the contract of the petitioner stood terminated. ঠিক আছে? এখানেই লিখুন the petitioner contends that the termination was contrary to the railway board
To the circulars passed by the railway.
circular
No policy.
relating to the COVID-19 বলে যেটা বলেছিলাম। ঠিক আছে? So it's disposed of. Would you like to file a representation?
Lordship kindly gives me that protection that till the representation disposed of, I should be continued to operate. Because the interim order is subsisting in my favor. There's nothing else.
I follow that.
Because there are 14 months. My contention is that I had 14 more months to.
Now 14 months is also over.
Not gone.
How many?
2 more months left.
2 more months left. All right.
Approximately. So kindly gives them 2 months period to dispose of by considering everything and allow.
কি বললাম লাস্টটা?
Last version of the senior divisional commercial manager from Southeastern Railway, Kharagpur, is directed to consider the representation.
Is directed to consider the case of the petitioner by granting him an opportunity of hearing to place all relevant documents in support of its stand and by passing a reasoned order. Stop. The authority shall take steps in the matter at the earliest, but positively within a period of 90 days from the date of communication of this order. Till a decision is taken and communicated by the authority. In this regard, the petitioner shall be permitted to run the business in the same manner as directed by the court in the order dated
25th June 2024.
25th of June 2024.
Page 9. ঠিক আছে?
ঠিক আছে? Writ petition stands disposed of.
I totally require that file my opposition to the can just for this.
All right. Affidavit in opposition to the connected application filed by the petitioner be taken on record. All right. Writ can both dispose.
Item number 3, my lord, it has been mentioned on my instance
Yes.
that a lookout notice is under challenge in the original writ petition, What happened, my lord, during pendency of the writ petition, there is a interim order passed by the coordinate bench of this honorable court that I may leave the country for business purpose, but I will have to give an undertaking intimating the originator of the lookout notice that for which period I am going to be abroad and the date of my return. My lord, pursuant to that, my lord, thrice, my lord, I have traveled. My lord, this is, my lord, the undertaking, my lord, as was earlier being granted. My lord, copy served to the originator. My lord, the undertaking discloses, my lord, the date of my journey and the date of return also. It's, my lord, for Bangkok, Phuket, Thailand.
Who is for the respondent? Are you there?
Lordship, I am appearing for the respondent bank, Lordship. Actually, the learned advocate who was appearing has been elevated to the bench, Lordship. He requires some time to file the opposition. Opposition has not yet been filed. I'm praying for 2 weeks for filing the opposition, Lordship.
But then who issued the lookout notice?
Lookout notice was issued by State Bank of India.
He is the originator.
Yes.
All right.
Now fraud has been declared and FIR has been lodged with the CBI. CBI is investigating. And also regarding the NCLT, PUFE application has been filed under section 66 for siphoning of funds. That is also pending. I will give all the particulars in my affidavit, Lordship.
No, but then he has annexed the travel tickets.
Yes.
Did you check up?
They have given undertaking, Lordship. He may go as per the earlier orders, Lordship.
Only one thing, my lord, my difficulty, my lord, may I just intimate before your lordship, my lord, the State Bank being the originator, my lord, the
State Bank,
RRO, my lord, the respondent number 3, the foreign regional registration officer, my lord, immigration department, they want that the originator should, my lord, inform his no objection through an email communication. Apart from, my lord, whatsoever, my lord, your lordship's direction, my lord, they being the immigration department, they want, my lord, this, my lord, earlier occasion also this problem arises. So let my learned friend, my lord, ensure that email communication should be there on behalf of the originator, intimating the foreign regional registration, my lord, officer, immigration department, respondent number 3, about the no objection of the originator pursuant to my lord's direction.
The email address will be supplied.
Yes, it's I shall.
you must be knowing it.
Yes.
You are the official respondent.
They will give a letter that will go with
You
the Lordship.
will.
I will do it, Lordship. The officer, yes, the new officer. has
The
come, Lordship.
officer should know it.
Yes, yes.
But is there any earlier order?
Yes, my lord, kindly takes up, my lord, I have annexed, my lord, first, my lord, direction of 27th of April 2023, directing me to file an undertaking declaration.
Yes, April.
Yes, my lord, if your lordship takes up the
23.
bottom portion of that 27th April order, lists the matter on 1st April for petitioner to file the declaration stroke undertaking. That was accepted, my lord, by the next order, 2nd of May 2023. Wherein, my lord, I was undertaking was given and I was allowed to, my lord, travel to, my lord, Vietnam for a particular period. Subsequently, my lord, this interim order was made absolute by the order dated 8th June 2023 in the disposal of the writ petition. My lord, the last portion, your lordship, kindly.
It is there, Lordship.
Thereafter, again, my lord, I filed undertaking and that was accepted by the order dated 24th of January 2024. And the time for extension of affidavit was being extended.
Union of India is there.
Yes, yes.
In my undertaking, my lord, apart from, my lord, tickets, my lord, I have disclosed where I am going to stay, my date of return also, and both the, my lord, flight details.
Please come. The petitioner has filed an undertaking by way of an affidavit annexing his travel plans and details of travel. Stop. Paragraph, it appears that by virtue of similar undertakings, the petitioner had traveled abroad earlier. Stop. Paragraph. Accordingly, now, copy of the undertaking has been served upon the respondents. Stop. The petitioner shall be permitted to travel abroad in terms of the undertaking given in court. Stop. A communication from the respondent number 4 shall be made to the respondent number 3 so that the petitioner does not face any difficulty at the time of immigration, you say. An affidavit of compliance after return shall also be filed in court. Stop. Affidavit has not been filed?
No, Lordship. An extension may be granted, Lordship.
This is the third extension, possibly?
Lordship, actually, the learned advocate was Mr. Justice
Yes,
Rai.
yes, that I can see. Achha. On the prayer of the learned advocate representing the bank, comma, time to file the affidavit in opposition stands extended till
2 weeks. 2 weeks, Lordship, from today.
Are you sure you'll be able to do it?
I'll be able to do it. I'll be able to do it. Lordship, then 4 weeks.
I can understand it was in January 24. We are in June 25. It has not been done. Achha, for stands extended till 8th of August. Reply, if any, within a fortnight thereafter. Stop liberty to mention for hearing.
That the affidavit of service be kept.
Yes, affidavit of service filed in court is taken on record.
Great, extremely grateful, man.
Pay for the petition.
But actually, this matter has been upgraded.
Without notice?
No, my lord, I have served.
Just now asked my lordship. He has served a notice on the passport officer. According to my letters written time and again to the Honorable Chief Justice, all notices have to be served in 11 stanzas. They are maintaining in terms of law ministry circular all records. So I missed the brief. I have gone through my non-engineer's brief. If your lordship wants to take it up, I have no objection.
What is
But
your
the
prayer?
Other
prayer is
Annexure P 8 and 9. These are not annexed to the petition.
Not annexed?
Not. Eight and 9.
Incomplete petition, have you served?
But I have served them twice.
Incomplete?
No, but I have always served a complete petition. I do not know, my lord, whether the department has, my lord, missed it. Because, my lord, I have.
What is your prayer?
My lord, prayer is.
What is
passport matter?
Yes.
Same question. Section 6(2)(f). Application which was filed before the London Criminal Court. This did not comply with the order required under the GSR 570. Kindly come to page 42. And other documents in respect of the renewal, these are not also submitted.
Did you approach the learned court?
Yes.
Yes. What it
kindly
says?
comes to page 42. Page 40 is the, there are two proceedings. These are proceedings under 144 BNS, that is 125 CRPC. Now, page 40 is the order passed by the learned magistrate. But there are two proceedings. The order in respect of the first proceedings, I have annexed both the orders. But if your lordship kindly comes to the fourth paragraph on perusal of the record, it appears that the record is in pre-trial stage and this is a record under section 144 BNSS. On further perusal of the case record, this court is of the view that it is the fundamental right of the opposite party to go overseas, for which this court has got no reason to issue an order for renewal of passport, and moreover, the instant case in which the opposite party is being tried in this case does not involve any case under the Indian Passport Act. My lord, however, I am directed to be present, and last line, this order may be treated as NOC. Now, my lord, thereafter, my lord, what had happened was, my lord, I had a passport. That passport was issued in 2014. It expired after 10 years on 17th of November 2024. My lord, I applied for renewal by filling up the application form. My lord, I disclosed that there are two 144 BNSS proceedings as against me. They asked me to obtain an NOC from the court. I approach the
Are you
court.
traveling abroad immediately?
No, my lord, I require my lord renewal because my lord, if my passport is not renewed, my lord, I won't be able to get a visa. But even if I have an intention to travel abroad, now my lord, how do they, my lord, both these NOCs were submitted before the kindly comes to page 43. Now my lord, they reject my application that I would require a permission to travel abroad. But if my passport is not renewed, I will never get a permission to travel abroad. But I am a employee, my lord, in a private sector. So my lord, first and foremost is, my lord, I have to show them a valid passport.
See, these issues are coming up in the court on regular basis.
Well, what can be done? Because your lordship has seen that I produced two judgments of the coordinate bench that in respect of renewal, everything has to be reopened anew. It's not simplicity renewal, number one. All documents are to be filed. Apart from criminal courts, no objection. Now he was asked to file documents, he did not file all the documents.
But I have filed everything.
Well, I am saying on instruction. Secondly, the order which has been passed by the criminal court, your lordship has decided in so many matters, it is not in conformity with GSR 570. The court has no jurisdiction to record. The learned court has no jurisdiction to record that there is no offence under the Passport Act. Is it the intention of the statute that only in case of an offence under the Passport Act, it has to be withheld? Any section 6 to 8.
Criminal case.
Yes, section 6 to 8. For the benefit of the citizens, in exercise of the power under section 22, this GSR has been issued. Therefore, on two conditions, he has annexed the GSR. The first GSR, the note it provides, there must be, kindly see, that page 46, your lordship has decided so many matters. This is the desire of the government of India in exercise of this relaxation is that if India he has to go proceeding in respect of an offence alleged to have been committed by them are pending before a criminal court in India and who produce orders from the court concerned permitting them to depart from. So permitting them to depart from must be the ingredients of making an application. What is the immediacy? Number one. Number two, the other point is that whenever an application is made, the court has to specify the period. If no period is specified, 1 year. Otherwise, these are the requirements has not been recorded by the learned judge in the criminal court.
Kindly comes to page 38.
38?
38.
No, the judge has given you no objection.
Yes.
But the permission to depart,
My humble submission is, but even if
to be there
in order to go abroad, my lord, there are two requirements. First is requirement is I have to have a valid passport, which is valid for at least 6 months.
You want your passport to be renewed, or you want your matter to continue?
But I want my passport to be renewed.
You approach the learned court below in terms of the GSR and get a
My lord, the learned magistrate, my lord, in my humble submission.
aggrieved by any order of the magistrate, there is a different forum.
Well, the learned magistrate says that until and unless I provide any travel document, the learned magistrate, my lord, is not able to specify the period.
In that case, you take it up in the divisional jurisdiction.
No, my lord, the learned magistrate says, my lord, because
what the magistrate says, this court is not going into.
The only thing is, if I don't have a valid passport, my lord, I will not get a visa to travel abroad.
Challenge the order of the magistrate. Please come. The petitioner is aggrieved by the action on the part of the passport authority in not renewing the passport.
No, may I leave?
Yes. Stop. The petitioner's stop. A criminal proceeding is pending against the petitioner.
It's a 144 quasi-civil nature.
Whatever is the proceeding, it is a criminal proceeding. That is the end of the matter. The authority requires certain documents from the petitioner for further processing of the passport application. Stop. The documents required have been intimated to the petitioner with a communication dated 28th April 2025. Stop. The petitioner submits that despite submission of all documents, the authority is not taking any step to renew the passport of the petitioner. Stop. The learned additional Solicitor General of India submits that the petitioner is required to comply the stipulations and as laid down in the notification dated 25th August 1993, issued by the Ministry of External Affairs by GSR 570 within bracket E, requiring the petitioner to produce order from the court concerned permitting him to depart from India.
But that was not their initial requirement. But kindly sees their own document, page 38. They asked for an NOC, simplicity and NOC.
Paragraph. It will be the instant writ petition is disposed of by observing that it will be open for the petitioner to take steps in accordance with the GSR mentioned herein above. Stop. Writ petition stands disposed of. Service taken on record.
The respondent bank have served the copy. Was delivered on 24th version. Without giving any
UCO Bank. Anybody there for the UCO Bank?
without giving any statutory notice to the legal layers of the alleged borrower, bank have issued a impending notice, Lordship, at page number 32 for dispossession, Lordship. I am the widow lady, Lordship. The allegation is that my mother-in-law had taken a loan from this bank. My mother-in-law died in the year of 2015. Thereafter, my husband has been died, Lordship, in 2019.
Is the bank communicated about the death of the
Yes, after
original loanee?
Having seen the sale notice in 2020, Lordship, I rushed to the bank and explained all these things, and they asked for 40 lakhs, Lordship. And even I did.
The figure is not important.
I don't know anything regarding the loan because 2015 my mother-in-law died. I am just residing over this property, Lordship. The property has been muted in my name and my daughter. Lordship, can you see the notice, page number 32?
Yes. Where is the paper publication?
Paper publication at Lordship, page number 24 and 25. It was issued, published in the year of 2020, the sale notice. From that sale notice, I came to know that there is a sale notice for selling my property, Lordship.
2020?
2020.
Why are you here now?
Lordship, the notice, impending notice issued in affixed on 18 June, page number 32, Lordship. Can you see?
So these all steps have been taken. Sale took place. Thereafter must be.
Sale took place, Lordship. The sale notice was published. I think sale was failed due to want of bidders, Lordship. I rushed to the bank. I requested them to please give us some documents regarding.
No, but then why will the writ court enter into all these things?
This sale notice, this notice, Lordship, kindly see page number 32.
I have seen that.
They have affixed the notice for dispossession from this property, Lordship.
Obviously.
Without giving any statutory notice to the legal layers. This is a settled principle of law. If the bank is taking action under the SURFACE Act even, then they have to give notice to the legal layers.
Yes.
Lordship, this is the judgment I am relying upon. The judgment of the Honorable Division Bench of Madras High Court, Lordship, kindly see.
What about this court? Produce judgments of this court. Madras High Court do not.
This court, Lordship, the coordinate bench has.
Or the Supreme Court.
Lordship, the coordinate bench has passed an judgment in the year of 2019, Lordship. Here, the coordinate bench said the notice is not required afresh if the 13 to notice, the initial demand notice served upon the borrower. But in my case, Lordship, the borrower died in the year of 2015. And from this sale notice, I came to know that the alleged 13-2 notice issued in the year of 2018. So, Lordship, there is no possibility for initial demand notice to serve upon the borrower. So, in my case, Lordship, there is no notice, statutory notice is served upon the borrower, not even the legal heirs. So, if the bank is going to take physical possession or any action under the Surface Act, bank has to give the notice to the legal heirs first. This type of arbitrary notice cannot disposes me, Lordship. This is the notice without any section, without any law.
You go before the tribunal. Why are you here?
Lordship, this is not the Surface notice. If I agreed by the notice under section 13(4) of the Surface Act, then only.
Listen, 13(4) stage is long over. Not go back to the 13(2) and 13(4) stage. You are not annexing documents.
Lordship, I have annexed all these. Lordship, kindly see my letter. Lordship, kindly see my letter to the bank. Lordship,
None appears.
I have asked the bank.
None appears on behalf of the respondent.
Lordship, kindly see once. Lordship, kindly see page number 27. My letter to the bank. Lordship, I have asked for all these
Affidavit of
documents.
service filed. None appears for the respondents. Affidavit of service filed in court is taken on record. Stipulate further notice we issued upon the respondents, intimating that the matter will appear in the list on Tuesday, 1st of July. Take all the judgments back.
Tuesday. We can pay.
Get from that.
Application list আছে that I have applied and participated in the NEET, qualified blood. Now I have to participate in the counseling process. I have applied for EWS certificate. And only yesterday I have got the certificate in D format, which is for central. If I apply under any central schools, and
yes,
then I have to apply under D.
Yes.
But D I have received yesterday.
Right.
C
So
I am
you are
yet to
waiting
receive.
for C.
Yes.
The state.
Malatik, he applied on 8th of April 2025. But it went to the ADM level only on 4th June 2025.
April to June, what were you doing?
By that time, what happened on 27th May, state government have published the new list of OBC categories.
It doesn't want OBC.
Yes, Malat. He is claiming
EWR.
EWS.
EWS.
Yes. OBC EWS. He is claiming.
You want OBC also? No, economic
provision is
section.
Provision is if
for
my
general
name is-
category, he has to apply on T
appearing under the central OBC.
Yes.
I cannot apply it for EWS category.
You cannot.
I cannot.
If you
my-
want central, you cannot apply for the state.
If my name is appearing in the central list of OBC,
yes,
then I cannot apply for EWS certificate.
All right.
I have not applied for OBC certificate. I have applied for EWS certificate only.
In the state?
In the state as well as central. Central I have received yesterday.
You are
The
waiting
same
for the
authority-
state.
Yes. If the format is different, when if you look to the circular,
The difficulty is that his subcast,
same inquiry.
Khondakar subcast is appearing in the state list as OBC category.
All these are subsequent.
It's absolutely online process. We cannot process it until and unless it is published as a general category candidate as subcast. We cannot process it because our list has been stayed by the this honorable court, and the issue is pending before the Supreme Court. Unless it is decided whether he is OBC or general, but we cannot process his application.
There cannot be any quarrel, Milad. I have already obtained certificate in D format.
If you can proceed with the D, then proceed with the D. Why are you waiting for the C?
See now. Now, Milad, the difficulty is what he is
Why
saying.
you will not get chance in the central college?
Yes, I can also apply for state also. But what he is saying now, there was a list published by the backward class department recently, in the last month, which was again challenged in a writ petition. That notification has been stayed.
Whatever. There is some
Has nothing
difficulty
to
on
do
the
with
part
my
of
matter.
the
Has nothing. Can you see what is the?
No, nothing to do. It has the court has to decide. The difficulty on the part of the state has been disclosed. If it is to be heard, then it is to be heard, and if you are okay with the D, then you can proceed with the D.
No, kindly see. I have annexed the notification.
Maybe then it has to be heard.
No, it's not required because the inquiry is the same authority. Inquiry has done. On the basis of same inquiry, he has to issue a certificate.
No, his submission, I have not gone through the instruction, but what his submission is that they cannot process.
It is own circular.
They cannot process the application.
Not correct. Clause 9.
Not I have annexed in the clause 9.
Issuance of EW certificate for those OBCs who are included in the state list. You claim OBC status also.
No, I'm not claiming.
But then clause 9 is EWs for those OBC.
If a person belong to, not claiming, belong to OBC and B category in the state OBC list of West Bengal, but not in the central OBC list of the state, he can apply. So, question
he
of
can apply. Kindly continue. Let him continue the entire paragraph.
Recruitment in civil post and services and admission in educational institution under government of India to avail EW reservation subject to fulfillment of other conditions. Such persons are eligible to obtain EW certificate in D format. Person already possesses EW certificate in in Annex C format by the competent authority also have to apply for EW certificate in D format while seeking reservation under the central government.
Already got it in D format. Then why do you want it?
I want in C format. That's
for
my point.
C format, what is
There
to be
is
done?
no impediment in C format.
Show what is to be done for obtaining it in
the
C.
Same inquiry?
No.
That I have
Inquiry. You show me how it can be got in the C
that
format.
I have annexed in my petition at page 23.
23.
This is the circular issued by the authority. And let inquiry at page 26, clause 10.
See page 23, the first portion reads serial number 1.
Yes.
It,
in order to enable economically
it only deals with EWS, not covered under the reservation.
Right.
Not covered.
Right. I am not covered.
Yes, he is covered. List published of or state government list published the list. He is under OBC B category.
That has been a state.
That have annexed.
And that is subsequent. He is saying because of this list, I cannot. The list was published.
He does not want the benefit of the caste reservation.
Not even
he wants only the
our portal, the list is showing.
It is technical.
We cannot process his application unless the list is altered. If the list ultimately survives.
Suppose somebody does not want to take the benefit of reservation, you will force him to take it. What is it? The petitioner says he doesn't want the benefit of reservation. You cannot be so mechanical.
To take instruction to that effect, whether it is possible or not. Kindly grant me.
And have to make it possible. Petitioner doesn't want reservation.
In this case, he is not want to take any reservations.
Yes.
Subsequently, he may claim further in
that is subsequent thing.
And this is for
one date. He says he doesn't want the reservation, but he wants only
Kindly grant me 1 day time.
EWS certificate.
Kindly grant me 1 day time.
Please come.
I appear on behalf of NTA. That's I will tell you something. 35.
Yes.
Point 2. Here, task general. Then applicant is to appear for hearing at the concerned BDO, SDO, DW Calcutta office on 2nd or 4th Wednesday of any month within 60 days from 12 noon and 3 p.m. after online submission. He has not, there is no amendment in the petition that he has.
That I have received from the sector.
He was to appear.
No, possibly he has appeared because he has got it. Maybe, but he has got it, which implies that he has appeared. He has got the certificate.
I have got the certificate. Yes, sir.
He has already got the certificate. Without the approach, the certificate could not have been issued.
But if the online application was made,
you are for the testing agency, so you do not have, so do not raise this issue. Whoever is the authority, let the authority raise such issue. And After the petitioner has got it, you cannot say that he did not approach. So, কি বললাম? The petitioner prays for issuance of the EWS certificate. Stop. In the application made before the state authority for obtaining such certificate, the petitioner has clearly disclosed that he belongs to the general caste. Stop. Specific submission of the petitioner is that he does not want the benefit of caste reservation. Stop. Paragraph. The EWS certificate in D format has already been issued in favor of the petitioner by the central authority. Stop. The certificate in C format from the state is certificate in C format from the state authority.
That certificate not issued by the
is-
central, that we issued
is
by
pending. Is
issued by
pending.
the state, madam.
Not the central. The
Acha, by the state in D format. In D format, central na D format has been issued. The petition, the C format is awaiting. What is the difference between this D and C?
D is for the central admission and C is
For
the
central admission.
same inquiry, same report. That's why I was submitting.
What is this?
Our portal is not permitting.
Then how can the D be given?
That is on the D format. But for the central only. For the state, since we have published the list, Khandekar as a OBC B category, if he claims for the state, that
You will force him to obtain the reservation.
Our system is.
You have got a faulty
That's the
system. Please change it. Please change the faulty system. You cannot force somebody to accept the reservation if the person concerned doesn't want it. Do you get it?
My lord, kindly grant me 1 day time, whether it is possible.
Yes.
How it is possible.
Well, that's why I have made prayer A.
What is prayer A?
Well, there are large number of candidates who are waiting.
Large number of?
Candidates who are waiting for this NEET.
Learned advocate representing the state respondents submits that as the surname of the petitioner is incorporated in the list of OBC candidates, as such, his application cannot be processed for issuance of the EWS certificate in the C format.
Yes, my lord.
Paragraph. The court is of the opinion that the authority cannot forcefully direct a candidate to accept the benefit of reservation. Benefit of caste reservation. Stop. The petitioner has himself disclosed that he belongs to the general caste and he do not intend to obtain the benefit of reservation. Stop. He only intends to have the economically weaker section certificate. Stop. To allow the learned advocate for the state respondents to take instruction in the matter. Release the same on 1st of July.
Well, there is an application, lad.
Yes.
There are other candidates who are waiting, lad. There are other candidates who also are applied for certificate, lad. They have intervened, lad. Let them take instruction. Lad. These are poor people.
Did you serve copy?
Oh, in email they have served, but now I'm.
Give a hard copy since he is appearing. When did you file it?
Not yesterday. Possibly it is in the list.
Is it in the
Listening.
list?
Oh, not in the list, madam.
It is in the list. Can 1 is there in the list. Can 1. Can 1. An application for being added as party respondent, not respondent, as party petitioners in the instant writ petition has been filed by similarly circumstanced candidates as that of the petitioner. File asheni? Kanta aniye nin. Stop. And none of the applicants seek with the benefit of reservation.
No, because they, as of now, they are not in that category.
You are sure?
Yes.
Stop. None of the applicants seek the benefit of caste reservation, but all intends to obtain the EWS certificate. Stop. In that case, I'll adjourn it for some more days so that he can take instruction, because he took instruction with only with regard to one. Thursday? Next Thursday? Yes, can will be served.
Please.
To NT also. You got it? Released on 3rd of July. And has the D certificate been issued to the applicants also? No.
That I have to ascertain, madam.
Take instruction. Can read along with can. As urgent motion should appear.
Lord,
Report was about to submit.
Yes.
But my lordship, on the last occasion, my lord.
may I respectfully invite your lordship to last order. My lordship, paragraph 6. I was supposed to, my lord, take instruction on this point, my lord. May I, my lord, respectfully hand over the instruction? It's not an aided madrasa, it's a Khariji madrasa.
It is a?
Khariji means not aided.
Not aided.
Lordship.
And
my lord, so far as the repair part of mosque is, it's within the domain of ASI. And repairing is underway. Kindly excuse me, the SDO Lalbagh has taken that point also in his report, my lord.
My lord, I am for the year of India. I have received the
instruction. Please forward. What is your prayer?
prayer is for repair the old mosque. My lord. That is within Archaeological Survey of India.
Yes. Please come.
Mosque and madrasa.
And madrasa. The madrasa is within the mosque.
Yeah.
Not within mosque. Lordship, it's not an aided, my lord, that remains, lordship.
The petitioner in the instant writ petition has prayed for a direction upon the respondent authorities for taking steps to repair the Motijheel Mosque and a madrasa, which is allegedly functioning from the premises of the mosque. Paragraph. The subdivisional officer Lalbagh has forwarded a report before this court dated 25th of June 2025, which clearly mentions that the mosque is being the mosque is under the control of the Archaeological Survey of India, Government of India, and the local administration does not have any role to supervise the matter. Stop. It has been mentioned that renovation work of the masjid is going on. Stop. The report specifically mentions that the madrasa which is being referred to by the petitioner is not functioning properly, and the same is not aided by the government of West Bengal. Paragraph. The superintending archaeologist of the Archaeological Survey of India, Raiganj Circle, has forwarded instruction signed on 18th of June 2025, specifically mentioning that the Motijheel Jama Masjid, Murshidabad was declared as a centrally protected monument in the year 2011. And since then, the monument is being looked after by the Raiganj Circle of the Archaeological Survey of India. Stop. The Archaeological Survey is taking continuous step to conserve and protect the said monument. But the process of conservation and protection is becoming a challenging job due to the illegal activities of the petitioner and the local residents of the area who are encouraging unauthorized encroachments at the site of the mosque by sinking tube wells and installing water tank on the roof of the mosque. Stop. Because of overflow of the water from the tank, the surface of the monument is getting damaged. Stop. Loudspeakers are installed within the masjid premises. Stop. The petitioner had cut a mango tree forcefully and has set up illegal shops within the fenced grill. Stop. The illegal act of the petitioner is contrary and in violation of the provisions of the Ancient Monuments and Archaeological Sites and Remains Act, 1958, as amended by the Ancient Monuments and Archaeological Sites and Remains (bracket open) Amendment and Validation Act, 2010, bracket close. Stop. Paragraph. The petitioner also has a habit of threatening the officials of the Archaeological Survey of India posted at the mosque whenever any opposition is raised to the unlawful acts of the petitioner. Stop paragraph. From the report filed by the authority, it appears that the that no aid is provided to any madrasa at the site of the mosque. Stop. In fact, there is no, the madrasa as alleged is not functional at present. Stop. By taking garb of functioning of the madrasa, the petitioner intends to intrude into the mosque, which is contrary to the provisions of the Act as mentioned herein above. Stop paragraph. As the masjid has been declared as a centrally protected monument, accordingly, the Archaeological Survey of India is directed to keep strict vigil over the property and protect the same strictly in accordance with the Act. Stop. It will be open for the authority to take all appropriate measures in the event any provision of the Act is violated. Stop. It will be open for the officers of the Archaeological Survey of India to take the assistance of the local police if any difficulty is faced at the time of protection of the monument. Stop. No illegal activity like sinking of tube well, installation of overhead water tank or installation of loudspeakers within the masjid premises,
And encroachments, my lord.
Setting up of stalls, cutting of trees within the masjid premise, within the fenced grill of the masjid premises shall be strictly dealt with by the Archaeological Survey of India. The writ petition stands disposed of.
My lord, may I get a copy of the report, my lord? Since there is allegation against me.
Or whatever the allegation is has been mentioned in the order sheet.
Get a copy, my lord.
No. Call the next one.
Good.
My lord, 8 and 9 can be taken up together. My lord, this is the evidential service of the 8, item number 8, my lord. My lord, earlier occasion, my lord, apologize, my lord, I could not be able to appear, my lord, day before yesterday, my lord. My lord, what happened? Your lordship was pleased to ask that since the petitioner preferred an application under section 6, subsequently he preferred appeal. 2 times appeal have been preferred. Subsequently, he prepared an application before this honorable court. An honorable court's pass and direction regarding that the department has to be submit the information what he seeks for. My lord, subject to correction, my lord, thereafter I got a document that the order regarding the order, it has been transferred to the another department. My lord, kindly see the annexure P5, that is page 36, for once. It was sent by the SIP of the West Bengal Board of Primary Education to the District Primary School Education of Malda, my lord. Subsequently, my lord,
First, you tell me
my lord,
the examination is of the year 2002.
2002, my
Why do you want information in 2025?
my lord, so far I have asked the concerned person. He told me that somebody told him that he will able to get this information from the department, so he can prepare any application before the concerned department, so that he can proceed with the, since age is a bar, my lord, since he can proceed with the any kind of examination in respect of the primary schools. So he
Examination was
Yes.
in the year 2002.
Yes, thereafter he also, I asked him personally, he also prepared, he also appeared in several examinations which in respect of the Malda Primary District Schools Council, but in respect of nothing he could not be able to get any kind of answer. But only thing I wanted to humbly submit before your lordship, I know there is 20 years has been passed. Now, my lord, question is that, my lord, if there is any answer regarding those documents, they provide the document,
come.
otherwise not, my lord.
The petitioner seeks for certain information in respect of a recruitment examination which was conducted way back in the year 2002. Stop. The court is of the opinion that the delay in approaching the authority for obtaining information which information of a recruitment examination conducted more than 2 decades back is fatal and no relief can be granted to the petitioner. Stop. The application made by the petitioner is hopelessly time barred. In view of the above, no direction can be passed upon the authority to provide the information as sought for by the petitioner. The writ petition fails and is hereby dismissed.
My lord, the second one in respect of examination of 2009.
Yes.
পরেরটা 2009 এর এক্সামিনেশন, তার মানে 9 থেকে 23 যত বছর হলো
My lord,
হিসেব করে
this
লিখে
is the
দেবেন।
affidavit of service.
14 years. So 14, 16 years. 20, 21, 22, 23, 14 বছর।
I'm getting to
Ten.
My lord, 10 I have for the petition.
Yes.
That matter, my lord, wherein I am seeking for
My lordship,
the
kindly
of-
direct the LR Miller to decide the issue as early as possible. For
And I have
appointing
suggested a name, my lord.
only
kindly
name,
say.
my lord, should kindly
I
keep
will
it to
not
the
write the
discretion.
name.
Leave it to the discretion of the LR
Yes.
But not from that court, my lord.
and timeline also.
That court.
My lord.
Why?
Contact.
Entire court.
No, there is a panel of the, my lord, separate
Special people.
special. Yes.
Yes.
From there, my lord, anyone, my lord.
Obviously. The petitioner
21 page
Mhm.
representation.
has been implicated in a criminal proceeding being Contai PS case number 195 of 2020, dated 15th of June 2020, under sections 498A, 304B, 34 Indian Penal Code. Stop. The petitioner is aggrieved by the manner in which the case is being proceeded with by the public prosecutor. Stop. A prayer for changing the prosecutor has been made by the petitioner, and the same is pending consideration at the end of the legal remembrancer for a considerable period of time. Stop. Without entering into the merit of the prayer of the petitioner at this stage, comma, the instant writ petition is disposed of by directing the legal remembrancer, comma, Government of West Bengal to take into consideration The petitioner's representation received by the authority on 28th of February, actually received by the office of the authority on 28th February 2024, strictly in accordance with the prevailing guidelines at the earliest, but positively within a period of 6 weeks from the date of communication of this order. 6 weeks, now 4 weeks.
Well, because the matter is not in a advanced stage.
Yeah, this is the reason 4 weeks I have reduced the time limit. Within a period, at the earliest, outer line is 4 weeks.
But kindly indicate that the appointment should be done from the panel of special public, my lord. Kindly do that, my lord. Otherwise, what will
Where, yes, where else from the appointment be made?
my lord, no, they will be doing from the impanel lawyers from the my lord, schedule for the landed court below, my lord. Suppose Meddepur, there is a panel of lawyers.
LR manual says, my lord, the LR.
Yes, yes, there is a panel.
My lord,
Yes.
we are not, my lord, my grievance is this, my lord, the person who was being appointed.
You want it from the list of special PPs?
Yes. My lord, they have the power to, my lord.
No, but then if there is any competent advocate in the LR panel, where is the problem? The
my lord,
advocates
that
panel?
is the difficulty because my lord, there are persons, my lord, the allegation against the person, my lord.
A particular person, you may have allegation.
But
You
my
cannot
lord,
have
I
allegation against the entire panel.
I intend to, my lord, have a special public prosecutor that can be done, my lord. That normally, my lord,
Listen to
is given.
the prayer of the petitioner for engaging any advocate from the panel of these special PPs may also be taken into consideration by the legal review.
ठीक, lordship.
Disposed.
My lord, I beg to appear on behalf of the petitioner, my lord.
I am for the primary.
Kindly come to the
state response.
Kindly come to the my lord's order dated 16.
Why do you bring your client to court every day, will you say? Why do you bring them to court? They are suffering, you said. Why do you tell them to come?
Last occasion, I could not get the information. Therefore, I think.
Telephonic information is not possible.
Yes, my lord. They are in.
Why do you bring them to court? They are suffering.
Yes.
They are aged persons.
That's good.
And you ask them to come to court?
Today I asked, but
why?
On the last occasion, they voluntarily come to court.
You should have told them not to come to court because this is not their place to come.
My lord,
They have engaged a learned advocate and the advocate will carry on the matter. If any information is required, you can always collect information.
I have told, but they are.
Do you understand the hassle and the trouble these senior people has to take to come to court?
Than me. they want to go back to their house, my lord. Kindly come to the order dated 16th of January, my lord. Passed by your lordship. Para number 11.
No, do not go back to whatever is there. What was the query on the last occasion as to whether there is any separate room where your son can stay?
This is the self-acquired property, my lord.
There is?
The property is a self-acquired
Please
property.
do not repeat your submissions.
My lord.
The court is aware.
My lord. I have told.
Query is whether there is a specific separate place for your son to stay.
No, I have.
Why do you want to take information in front of the court?
Only 2 rooms are there, my lord.
Where?
At the Raiganj, my lord.
At the?
Raiganj property, my lord.
At the top floor?
This is only ground floor property, my lord.
Only single storied property?
Yes, my lord. 2 rooms is there and one is for the worship place.
All right.
There is nothing else.
There is nothing else.
One is the garage, which is in occupation of the respondent number 6, and one additional room. Huh?
There are 5 rooms in the one story. There are 5 rooms.
That
3 rooms in the occupation of the petitioner.
First,
and 1 room. There is a
and the most
separate kitchen
important thing,
space,
my lord,
drawing space, toilet. All right.
Please wait. Yes.
I have talked to them, my lord.
Yes.
They are not willing in any way manner to reside with the respondent number 6, my lord, because of the immense cruelty and the torture inflicted by the respondent number 6 upon the petitioner, my lord. That has been the submission before the division bench, my lord. A division bench also affirmed my lord's order. That's the property.
It is a single story structure.
Yes.
The petitioners are not comfortable to stay with you. So, You are to move out. How soon? How soon?
Not as on today, I have no means to accommodate myself unless and until.
Then look for some place where you can get accommodation gratuitously. There is no other option. The petitioners have to be put back to their place. They are senior citizens suffering from terminal diseases. Right? Nothing doing. Please move out. Otherwise, the court has to direct the police to throw you out, which will not be very good, considering the fact that your client is a member of the profession.
My lord,
Right?
my lord.
So please move out. You are not even providing maintenance to your parents.
No,
My lord,
not
Because
I have no
even
means
they have
to.
not.
you do not have means.
My lord.
So the petitioner may intend to let out the property for earning something to take care of their medical needs.
My lord, great.
So please, how soon?
Yes, my lord, if your lordship so pleases, I'll do. But my lord, kindly consider at one point of time.
No consideration.
But let me finish first, my lord.
I have heard your submission. Do not repeat. The court doesn't have so much of time.
That this court
Please
has
come.
passed the direction on the in January month of January, my lord. Now we are in the month of June, my lord.
The petitioners are personally present in court, though there was no such direction for their personal appearance. Stop. It can be seen that the petitioners are fairly senior citizens and are not of a good health. Stop. The petitioners have disclosed that they are not comfortable and do not feel safe to stay in the same premises with the daughter-in-law and the son. Private respondents quoting. Private respondents. Stop. Paragraph. In the property in question is a self-acquired one. Stop. The petitioners require finance for their medical treatment. Stop. The petitioners are not being taken care by their son, and no amount of maintenance is being paid to them. Stop. Paragraph. Under such circumstances, the court is of the opinion that the private respondents ought to vacate the property so that the petitioners can enjoy the same peacefully and safely, free from the fear of their lives at the hands of the private respondents. Stop. The private respondents are directed to move out of the property by 30th of July 2025. Stop. The matter is directed to be listed once again on 31st of July 2025.
And
In the meantime, the officer in charge of the jurisdictional police station shall ensure that there is no breach of peace or tranquility at the locale, and the life and property of the petitioners are not threatened at the hands, threatened and infringed in the hands of the private respondents.
Kindly allow me some more time, my lord.
Prime respondent be directed to hand over the keys of the property, my lord.
No more time can be given because enough time has been given to you for quite some time. Acha. On vacating the property, the keys shall be handed over to the officer in charge of the jurisdictional police station, and it will be open for the petitioners to collect the same from the police station. On being police station stop, the police shall intimate the petitioners. No, take it to the police station. Yes.
I'm good.
Number 12, I'm appearing for the bank, Lordship. My lord, in item 12, my lord, I appeal for the petitioner. My lord, this is my writ petition against the notice under section 13(4) of the Sufficy Act. My lord, my principal-
Party man. My addition of.
May I just briefly indicate my writ petition, my lord? My lord, this is my challenge against the 13(4) notice, which is page 27, my lord. My principal grounds of challenge are that no 13(2) notice was ever issued to me, no prior intimation was given to me, and the 13(4) notice, which is to be delivered to me as per Rule 8 of the security interest rules, that was also not given. My lord will kindly.
Which page is it?
My lord, it is at page 27.
27.
27. My lord will kindly.
State Cooperative Bank. Possession notice.
My lord will see it is not addressed to any person.
Yes.
Secondly, my lord, in page 28, it is a continuation of the same notice. My lord will just see the description of immovable property. 1, 2 is personal guarantee of proprietor of such and such. My lord, I am not the borrower. This notice has been affixed on my house on the purported allegation that I have created some security interest. No, my lord.
You are not Messrs. Das.
No, my lord. That is response number 2 before, my lord.
Traders and guarantors.
No, my lord.
All right.
My lord, this notice has been issued on the basis that some alleged security interest has been created by me. The borrower is respondent number 2 before, my lord.
Anybody representing the respondent number 2? All right.
My lord.
Who is for the bank?
My lord, I am appearing for the bank.
All right.
My lord, this matter, my lord, Lordship kindly sees, my lord, the plea, my lord, the.
Let me hear. I just wanted to inquire who is there. Yes. Page 28 I have seen. Thereafter. How are you connected with this property?
My lord, I have no connection with the respondent number 2. We are
responding with the property.
My lord, I am
Recent
one of
parcel of land.
Yes, madam. I am one of the co-owners of the property.
One of the co-owners. Who is the owner?
My lord, the original owner of this property was my father. After my father has passed away intestate, I, along with my siblings, are now presently the co-owner of the property. My lord, the Porcha is at page 15.
Who is your sibling?
My lord.
Messrs. Das and Sons.
No.
They are not.
Completely unconnected.
Yes.
Yes, my lord. My lord, this is, my lord, I understand, my lord. My lord has expressed my lord's mind in several judgments that a section 13(4) notice challenge should always go before the DRT, my lord, apropos section 17 of the Sufficy Act. My lord, my limited ground, my lord, is that the possession notice is completely arbitrary. It is not even addressed to any person. If my lord sees, kindly considers page 27. And in page 28, under immovable property, they are also including a personal guarantee given by the respondent number 2. This is my limited.
Tell me one thing. This possession notice is dated January 25.
Yes, my lord.
Why have you come up now?
But I had filed the writ, my lord, sometime back in
May 25.
May 2025. Yes, my lord.
Right. What happened in May? Why did you file the writ petition in May?
My lord,
That means they did not take steps in terms of this notice?
Till May, no steps were taken. My lord, apropos to my lord's query, I have tried to explain it in my writ petition that the moment I got to know that some security interest was purportedly created on my property, I had tried to approach the bank multiple times on the hope that the bank will clarify. Because even the possession notice is not addressed to me. My name does not even appear once in the possession notice.
All right, let me understand what things
Lord,
are.
Lordship kindly sees, my lord, it is, my lord, their own averment, my lord, their date of knowledge back in the year 2016. Lord, page.
Tell me one thing, page 27 and 28.
Yes.
Is it meant for somebody?
No, my lord, this is a notice for symbolic possession. My lord, my learned friend is submitting, it has to be addressed. My lord, it need not be addressed. It is as per, my lord, the rule. My lord, security interest
you
rules.
are taking possession of what?
Yes, my lord, the property, my lord. We are taking possession of the property at 62 by B. My lord.
Where is the address mentioned?
Yes, my lord, Lordship
62 by
kindly
B,
sees.
Khudiram
No, my
Sharan.
lord, the description of the property at page 28.
Yes.
My lord, 138 decimals of land, Mogra Road, Swanso Gram Panchayat. This is, my lord, the immovable property we are taking possession of. Now, my lord, 13(2) issued, 13(4) thereafter issued. Now, my lord, Lordship kindly sees, my lord, the person, my lord, who is filing this writ petition is the guarantor. My lord, he has specifically disclosed, my lord, in the writ petition, but my lord, it has not been, my lord, submitted. I do not know why. My lord, my lord, is the guarantor of the property. His plea is that since he...
Guarantor of the loan.
Yes. Now, my lord,
The person concerned is no way related to the property. 138 decimal of Moja, such and such.
No, he is also one of the owners.
I am one of the co-owners. Co-owners. All right.
Now, my lord, Lordship kindly see, my lord, the plea taken in this writ petition that he is an illiterate person. He didn't know, my lord, the consequence of the execution of the, my lord, particular, my lord, document. It fraud, my lord, practiced on him. And, my lord, he...
All those are different things.
Now, Lordship kindly sees, if an illiterate person, my lord, signs, my lord...
that is all right. Thing is the petitioner anyway connected with the loan?
Yes, he is the guarantor.
He is the guarantor.
Guarantor.
You
And,
have
my lord,
documents to show.
my lord, today, my lord, I do not have, but my lord, his own averment. Lordship kindly sees, page 3, my lord, 5C.
Respondent number 2 took a loan from the respondent. The petitioners was exploited. The petitioner was made to sign on a guarantor for this.
So, my lord, any my lord, grievance, my lord, it has to be sorted out under section 17.
Who are you for?
I am one of the owner. I am not related in any way, my lord. I am one-third owner.
One-third owner?
Yes, my lord.
Who has obtained the loan? The sons?
I have no knowledge at all, my lord. As soon as I seen this possession notice, my lord.
Messrs. Das and
came
Son
to know
Fish
that
Traders.
my brother filed a writ petition by the application for additional party, my lord.
So
my property is...
Who is the other person? Messrs.
Another
Das
brother.
and Son?
This is the sole proprietorship of Kamal Das. He is the borrower. That is what I have gleaned from the 13-4 possession notice. He is the
No,
actual.
but then since you have already averred, please come. The petitioner stood as guarantor to a loan obtained by the
My
petitioner.
lord, I have first created, my lord, the allegation is creation of security interest, my lord. There is no allegation of creation of guarantee.
Respondent number 2 from the bank. Stop. The bank has taken steps for recovery of the loan amount under the provisions of the SARFAESI Act. Stop. A possession notice has been issued in January 25. Stop. Challenging the same. Writ petition has been filed by the petitioner in May 2025, alleging that the petitioner is no way connected with the loan. Stop. The notice under section, now the notice under the provisions, the notice says under the provisions of the SARFAESI Act were not served upon the petitioner. Stop. The petitioner claims to be one of the co-owners of the subject property. Stop. Paragraph. Prayer has been made to set aside the possession notice, which according to the petitioner is a vague one, bereft of all necessary details. Stop. Paragraph. Learned advocate representing the bank draws attention of the court to the averment made by the petitioner, specifically mentioning that the petitioner was made to sign as guarantor for the loan obtained by the respondent number 2 from the bank. Stop. The aforesaid averment makes it very clear that the petitioner was aware of the loan agreement. Stop. The loanee has failed to liquidate the loan amount and the bank has taken steps to recover the same in accordance with the Act. Stop. Paragraph. Any person aggrieved by any steps taken by the secured creditor to recover the loan amount ought to approach the statutory forum for relief. Stop. The relief sought for by the petitioner in the instant case cannot be allowed. The writ petition fails and is hereby dismissed.
Grateful.
The connecting application filed by one of the co-owners of the secured asset stand on the same footing as that of the petitioner. Stop. The said application also fails. Dismissed.
Malad, may I just say one thing, Malad? This is 13 for notice under surface is securitization of property, Malad. Guarantee has, Malad, in my response submission is different, Malad. Grateful.
My lord.
Hmm. এটা পড়া যাচ্ছিল না।
Lordship, may I be permitted to mention a matter?
Permit to mention, my lord, item number, my lord, 318 and 319. It was in the 19th June, my lord. It was in a 363 and 364. Your lordship directed to upgrade the matter because, my lord, in contempt proceeding, my lord, your lordship directed that to release my pension. But today, my lord, not upgraded, my lord. Your lordship, my lord.
Bring your other side.
Bring, when, my lord?
Bring your other side after the regular matters are taken up.
Lordship, item number 60, Your Lordship, there's extreme urgency in the matter, Your Lordship. Item 60 of Your Lordship's daily list today, Your Lordship.
You are for the petitioner?
Yes, Your Lordship. Your Lordship, actually, the transfer petition for those applications were filed in the NCLT in a particular bench, Your Lordship, and that had to be transferred. So for such transfer had to be made by NCLT Delhi bench. Now Delhi bench is under vacation, Your Lordship. So Your Lordship, I'm humbly praying that this matter be heard, Your
But this
Lordship.
is a writ petition. Why are you mentioning it at this point of time?
Your Lordship, I humbly apologize, but it's extremely urgent, Your Lordship.
I cannot help. Please come on Monday.
My lord, I've mentioned in the morning earlier that a contempt petition is pending.
Please wait, let the regular matters be taken up.
My lord directed to bring the other side.
Yes, you have to bring your other side after the regular matters are taken up, not prior to the list being called. Call the list, please.
For the petitioner.
Yes.
Is 20. I want modification of your lordship's order, my lord, the dated 25th April 2025. Page 20. My case was, my lord, my application should be considered on the basis of the law prevailing at that material point of time. That was also my prayer. I have set out the prayer in the application. The paragraph 3 and 4, I preferred an appeal against my lord's order.
No, but then you relied upon this notification, isn't it?
Notification was already placed before your lordship in other cases. That is why my lordship passed the usual order. But the paragraph 3 and 4, if it is submission on my behalf, then my lord, the order division may said that no, this order was passed on your submission.
So was this not your submission?
No, that was also not my prayer. My prayer was, my lord, I have also set out my prayer. Division means also already, my lord, settled. My lord also knows, my lord, this is the settled law, my lord. When the application was made, was proceeded through SOC portal, my lord, the law.
When was it made?
My lord, kindly see my prayer, prayer 6, paragraph 6. I have set out my.
When was the application made?
That 14th August 2021. That is the paragraph 6. Set out my. I have set out my prayer. That also, my lord, annexed also in my application. In my.
In your prayer, where is the date? I don't see the date in the prayer.
Yes. Application for transfer through SOC portal on 14th August 2021. Page 8.
Yes.
That is my the date of my application. But the 3rd January notifications, my lord, is not applicable to me. My lord, can my lord
what is the what was the rule prevailing at that point of time?
Well, there is no provision for single teacher. They have rejected my application on the ground of single teacher. There was no provisions.
No provision means?
There is no provisions for
Rejection
my application on the ground of single teacher.
All right.
Even then, a single teacher conceptions comes, my lord, after 8th September.
Yes, but then when was the rejection made?
That is rejection made by lordship, page 16, 1/6. 30th August, serial number 2, 1/6.
have annexed my status application for status of my application. To appear for you.
Who is your other side?
Mr. Subir Kumar Saha, I think my lord, he is online.
No, service commission, school service commission is required.
My application has not yet reached to the school service commission. My application has been rejected by the DI, concerned DI.
Or DI secondary.
DI secondary. That we also find my lord page 6 or 16, 1/6. Oh, yes, yes.
No, school service central school service commission has decided it for backward to the DI. The Central School Service Commission, Mr. Sunit Roy appears, isn't it?
In this matter, yes, Sunit Roy appear.
Give one notice, come back.
Yes.
Ache ki? Ache?
Sunit Roy ache.
No, Mr. Shantanu is there.
Unmute করে রেখেছে।
কি আছে কি?
Hello, am I audible? My lord, am I audible? Sorry to appear like this, my lord. I have been informed just right now that this matter has been listed. No notice was served to the state, my lord.
You are not in your robes, so please
Yes,
do
my
not
lord.
appear.
Yes, my lord.
Please
That's
do not
why.
appear. Please switch off the camera. None appears on behalf of the respondents. Stop. Let notice be served. Released next Thursday. Next Thursday. Will you be able to serve by next Thursday?
Yes, yes. I served my lord upon both the advocates.
Yes, yes.
Item number 412, Lordship.
Call item 71.
Item number 71.
May I lordship, I am for the petition.
Lordship, I am appearing under the contemner. My affidavit of compliance, Lordship.
My lord. My lord, only my lord, my grievances are not paid my remuneration. The subsequent ASHA program is come, my lord. But I am discontinued and we are the link man. But the period
1 minute
from which I was started, my lord, work from 2012 to till date. This period I was work but not paid any remuneration. That is my grievance only.
BMOH. Are you appearing for BMOH?
Yes, your lordship.
Is the BMOH present?
Yes, your lordship. Yes,
Why
sir.
did he not appear on the last occasion? Why was he not
Lordship,
represented?
Lordship, I have explained in my affidavit of compliance in paragraph 7. I was engaged on 16th May 2025. That is on the next date of the passing the order by your lordship, your lordship.
But
And
then
I have annexed the document, your lordship. Kindly come annexure B. Annexure B of my engagement sheet, your lordship.
Notice was served upon your clients prior thereto,
Yes, your lordship.
right?
Yes.
Why did he not take steps to engage somebody?
Lordship, he is the BMOH. He contacted the district.
After
CMOH,
the
your
contempt rule is issued, then he will
contacted CMOH Paschim Midnapur. Thereafter,
he is a government employee. Please make him understand that when there is a court's order, he is required to follow it.
Lordship, I beg pardon on his behalf.
Did you serve the compliance upon your learned friend?
I am serving your lordship. Oh, I have served already.
What is it? Has the order been complied?
No,
Has the
no complaint.
no, not complied. Where is the
compliant
non-compliance?
My grievance was, my lord, before your lordship, on 11th of
March 2020.
Oh, 1 minute. There was a
No
delay.
remuneration has been paid only for the person. I have, my lord, Asha program is come. Asha Komi subsequent, the Asha Komi has come. But during the period from 2012 to till date, my lord, I was working but not paid my remuneration. Only this portion. Not paid.
Annexure D, your lordship, the earlier reasoned order passed immediately after your lordship's order, and Annexure E is the lordship, the present reasoned order referring your lordship's order and WP number, your lordship. Only that was the inadvertent mistake by the BMOH.
আমি এক্ষুনি আপনাকে দেখার জন্য কপিটা কোথায় এই যে তাহলে কি আমার কপিটা দিয়ে দিলাম তো আমার কপিটা দিয়ে দিলাম আপনাকে এবার নিয়ে নিয়ে আমার কপিটা আপনাকে দিলাম এটা কি দিয়েছে আপনাকে এটা তো আমার কন্টেম্পলেশন
Yes, what is your submission?
My lord, my submission is only not to pay the remuneration. My lord, I am paying before lordship to direct them, the BMS to pay my remuneration.
Remuneration for what? Remuneration for what?
For what I am working as a linkman from 2000.
No, the linkman has this work has been abolished after the introduction of the Asha scheme. Why will payment be made to you?
My lord, I ask myself why they have worked me from 2012 to till date.
You are still working? Are you still working?
After filing the application, my lord, from the COVID period to till date, I am not working.
But prior to that?
Prior to that, I am working.
And you did not get anything?
No, not a CL vice. Show me the, my lord.
Show me that you have worked. Where is the proof of your service? What type of work did you perform?
They did not, my lord, they did not, my lord, not admitted. That's why I'm working or not. They admitted. It is admitted fact that I was working since 2020.
The BMOH. Give his name. Is personally present in court in response to the contempt rule issued. And they peruse the affidavit of compliance filed by the BMOH. Stop. It appears that the petitioner could not be paid the incentive because the scheme of link person stood discontinued after the joining of the Asha Kormi in the rural sub-center area. Stop. Paragraph. The petitioner asserts that she performed the work as link person.
Link person.
Stop. The said assertion is denied by the BMOH. Stop. Paragraph. As it appears that a fresh order has been passed by the authority and the petitioner is aggrieved by the same, it will be open for the petitioner to challenge the said order in accordance with law before the competent forum, if so advised. Contempt application stands disposed of. The personal rule, the contempt rule stands discharged. Personal appearance dispensed. Next.
I'm appearing for the Kolkata Municipal Corporation.
Microphone.
This pertains to illegal construction, my lord. At page number 28, my lord, we'll find your ladyship's order, my lord. The operative portion is that, my lord, the last paragraph, the spot inspection report mentions that a statutory appeal being such and such is pending before consideration. The municipal building tribunal, the next date is such and such. Admittedly, as on date, there is no order of staying the order of demolition. Since it has been brought to the notice of the court that a statutory appeal is pending, the next date of hearing is fixed on such and such. Accordingly, the corporation is directed to stay their hand. Still, 29th February 2024. If the person
What happened to that statutory appeal?
My lord, the statutory, as on that date, my lord, there is no stay. And my lord, I have the order copies, my lord, 18th December 2000 and my lord, 24, the stay application was moved and it was, my lord, rejected. Now the appeal is pending, my lord, but there is no stay, my lord. My lord, now, my lord, on my lord, last week, my lord, on my 19th of June, an order was passed, my lord, directing the learned advocate for the contemners to seek instruction as to whether this stage.
My lord, demolition work was started, my lord, and need more time to demolish the.
Are you aware whether demolition work has
But I
started or
have
not?
instruction that, my lord, there are occupants still now. They have not
Whether
left.
demolition work has started?
My lord, after my lord passing of the order, 2-3 days back, my lord, the work has been initiated.
Fourth, my
My
lord.
lord,
I have stated.
if your lordship takes our report,
It has been
this last
initiated.
page and page 28 may come to your lordship's assistance, my lord. 28 and the last page. My lord, third to sixth floor, according to our report, are vacated.
Yes.
So, my lord, there might be people in the first to third, second floor, ground to first, second floor. Probably that is what my learned friend is referring to.
The 3rd to 6 is the
Unauthorized portion.
Yeah. Yes.
Let them demolish. Please come. Learned advocate representing the contemners of the corporation. Submits the report forwarded by the Municipal Commissioner, Kolkata Municipal Corporation, signed on 25th June 2025, wherefrom it appears that the work of demolition of the unauthorized portion has just begun. Stop. Next. The top 3 floors of the 6-storied structure is unauthorized. Stop. Learned advocate representing the
I am 4.
contemner number 4 relies upon the report forwarded by the Deputy Commissioner of Police, Port Division, signed on 26th of June 2025, which also mentions regarding demolition being carried out in the top floors of the unauthorizedly constructed premises. Constructed structure. Stuff. Next. Hearing of the contempt application stands adjourned till 7th August 2025. An updated report by the contemners shall be placed before this court on the adjourned date. Stop. The process of demolition shall continue till the unauthorized portions are completely demolished.
Matter appear at the same position in the list.
It is there in the list. The people are working on it. See what happens.
33.
Yes.
পাওয়া গেছে? হ্যাঁ?
Child care leave policy.
Lordship, I am appearing on behalf of alleged contemner, file forwarded to the highest authority, Lordship, for policy making decision. They will take some time, more time. They need more time.
The court passed order on August 12, 24.
Yes, Lordship, file forwarded to the.
Forwarding is not enough.
No, Lordship.
Then?
They need more time, Lordship.
How long?
4 weeks, Lordship. 4 weeks. Kindly give Lordship 4 weeks.
Who has given you this instruction to seek for 4 weeks time?
Finance Department.
Finance Department. Are you sure that within
Yes,
4
Lordship,
weeks
yes.
the policy will be put in place?
Yes, today I just asked before this matter. They prayed for only 1 month time because file already forwarded to the highest authority.
Who is the highest authority over here?
particular person নামটা বলুন
Because only
Contempt.
finance possibly cannot take a decision.
No, Lord.
There are other wings of the government.
It is forwarded to the most probably cabinet, Lordship.
Not most probably. You should be ready with proper instruction. I'm passing it over. Take instruction where exactly the file is lying. Right?
Very well, Lordship.
Call the next matter.
Should I appear for this fee? I appear for the petition, my lord. This also pertains to, my lord, illegal construction. The last week, my lord, at the time of rising, I mentioned this matter citing urgency that the petitioner, my lord, is in constant threat, my lord, to withdraw the even, my lord, contempt application. My lord, I have also made, my lord, complaints, my lord. I have, my lord, may I have the leave to file the supplementary affidavit?
Yes.
Bringing on record, my lord.
What about the position of the demolition?
Today also it is continuing. My lord, it is not. My lord. I have the updated
I
report.
made to appeal, Lordship, for the contempt.
Updated report, my lord. It is that date is mentioned over here, my lord. It is and my lord, the my lord, time is also indicated, my lord.
জানা বাবু আপনি দেখুন দরজাটা কিন্তু
My lord, the report is here.
yes.
Demolition work was in full swing.
But today also it's
19th, no, kindly see the report. 19th, my lord, 19th, my lord, matter was due to appear before Lordship. 19th, somehow matter did not reach. Therefore, it could not be taken up. 19th also, this report was prepared on 19th.
No, 25th June.
One second. 19th. No, last date, my lord, I'm explaining. The last occasion, kindly, my lord, the last paragraph. It is very clearly stated that on that day also, when the report is being prepared, then the demolition work also going on. And it is also still, my lord, some portions are there that is to be. তুমি last report কি নিয়েছো আজকালের ভেতরে নিয়েছো?
Your lordship,
Where are the photographs? Are the
Yes,
photographs
my lord, yes,
annexed?
my lord, that I'm giving. I'm showing to Lordship. This is the photograph, Lordship, can you see? These two photographs were annexed, my lord. Have a look to this. So, my lord's order has been, my lord, we're trying, my lord, in full swing, my lord, with full spirit and respect.
What is the nature of the unauthorized construction?
But if your lordship kindly takes up our report, Lord, we have details. We have given detail.
No, the corporation is here. Let me hear them. Yes.
G+2 is, my lord, sanctioned.
And
Up to G+2, my lord, the additional floors are illegal. My
how
lord,
many additional floors?
my lord, demolition order is also on record, my lord. I have, yes.
See, Mr. Nayak,
My lord,
this is the photograph which has been taken today.
I do not know. Let me have a copy so that I can take.
Yes.
Yes, my
G
lord.
plus 2 is sanctioned and this is the structure that is standing today. And you say the demolition work is going on.
I'm not saying this is my
Right.
instruction. I'm saying, your lordship.
You means your client.
My lord.
There is nothing personal. Please take it. So, thing is that instruction is that the demolition work is going on.
That is the report also.
Take care of this.
My lord, certainly. My lord, I do not know. And at the same time, lordship, the GBC, my lord, GCP is showing in the letter.
Yes,
Now the
yes.
building, I do not know whose building is it. I do not know whether the existence of the building, the demarcation is something. Some demarcation portion, demarcated portion is also there. I do not know that has been demolished or not. Might be some surrounding building may be there. I will take instruction. I will come back so that I can, my lord, clearly.
No. I didn't follow. Is it a submission?
I
that
say that since my report, I'll have to, my lord, certainly believe my client. If they give wrong information, consequences will follow.
No, that is
So
different.
my instruction says demolition is going on, and my lord, that picture also they have shown.
The picture is that holes are being dug,
Yes.
not the outer walls. Your picture shows holes.
Yes, my lord.
Yes.
I'll take clarification on
Yes.
this. And if this picture, the building
Yes.
is exactly the building in question.
Entitled Walter. That is the wall. Blood inside, blood entire roof and demolished.
Yes, I can
In order
see.
to,
The
balance, in order to balance, blood the entire building, it will be demolished also.
Please come.
My lord, that aspect, my lord, that
I will see. Report by the contemners of the corporation and the police filed in court today are taken on record. Stop. The contemners report suggests that the work of demolition is ongoing. Stop. Paragraph. The photograph of the structure standing today has been handed over to the learned advocate representing the corporation for onward transmission to the authority for taking necessary steps for compliance of the court's order. Stop. The petitioner has filed a supplementary affidavit mentioning that he is under physical threat for proceeding with the contempt application. Stop. Paragraph. The petitioner lodged complaint before the officer in charge, Koraya police station, indicating the names of the persons who are constantly threatening the petitioner with dire consequences. Stop. Paragraph. The police is directed to ensure that the life and property of the petitioner is not infringed by any person whatsoever.
But in the report, my lord, case already been started by the
All right.
on 1st June. Korea appears case number 144. Para 7 of the report. Next, second page.
The case registered by the police on receipt of the complaint of the petitioner should be investigated properly and the same should be concluded without any delay in accordance with law. The not the hearing of the contempt application still stands adjourned till 7th August. Updated report from the contemners be placed before this court on the adjourned date.
May I file the affidavit?
Grateful, Lordship.
Service is also taken up.
I'm deeply obliged, Your Lord.
Affidavit of service. So grateful.
Grateful.
Why?
No.
I beg to appear with the alleged contempt, my lord.
Order has been complied with. Very well. Learned advocate representing the petitioners submits upon instruction that the order passed by the court has been complied with. In view of such submission,
May I hand over this, my lord?
yes, certainly. Instruction forwarded by the contemner,
But not addressing me, my lord.
all right. Be written with the records. The contempt application stands disposed of.
দিয়ে দিয়েছি।
But I appear for the alleged contemner.
Yes.
On the last occasion, 15th of May, my lord, I have paid 4 weeks of time on the plea that an appeal is pending before the division bench. My lord, I have also stated the restoration application is there, which is yet to be decided. My lord was kind enough to grant me time and the matter was directed to appear today. My lord, when I was on the verge of mentioning the matter, my lord, I was communicated by my department that the petitioners have, in my lord's, the impugned order, my lord, the compensation has been directed to be payable in terms of 2013 Act. Now, my lord, appeal was on such score that in no circumstances it could have been paid under the 2013 Act. At best, it is a case of direct purchase. Now, my lord, when I was about to mention, my lord, I was communicated with this letter by the department, which says, my lord, and I was communicated also, my lord, that the petitioners are agreeable to a direct purchase. Compensation, my lord, payable under the direct purchase policy of the state. My lord, I am surprised that my learned senior friend, possibly, my lord, is not briefed on this. He is, my lord, possibly not let him make him submission, his submission made.
What happened to the appeal and the restoration?
Milord, I did not mention it because there was a terms of settlement going on. So, Milord, I did not mention. Now, Milord, possibly my learned senior friend says this is on some caution. I do not know. He has told me that. Now, Milord, I am at a loss, Milord, honestly, Milord, because the authorities, Milord, I was communicated that the petitioner has come. Milord,
Position of the court, you understand?
I understand, Milord. I'll tell you, Lord, what I have thought, Milord, if the petitioner today.
What is the stand of the petitioner? Is any talks of settlement going on?
I request not to invite me to address something. Kindly have a look at the letter.
Yes.
I was compelled to sign.
Take instruction whether the petitioners are
But
agreeable.
there are 4 petitioners.
Yes.
Only 2 have signed. Not that the petitioners have agreed. 2020 order passed. And today we are the moment your lordship intervened, then they rushed to me, invite me to office, and they drafted it, I had to sign. Kindly have a look at the language.
Very well. Is it your case that you are not agreeable to this?
Other 2 petitioners are not agreeable.
These
I have to talk to them, my lord. They are under what prompted them to accept this, or why not they did it earlier? Because when I moved this writ petition,
Oh, you moved it in 2020. Things were different. Now it is
when that
contempt
on that
court.
time a direct purchase policy was there, and that was the approach before the honorable court. My client did not agree to that. Only thing is this, my lord, let them come out with the date. Then when they are going to pay me
I'll come
by
up.
way of purchase.
I'll come up. I'll come up.
Then
Will the other 2 also agree to the direct purchase?
Then I can impress upon them to either to accept it or not to accept it. Or at least I should know when they are going to comply with to do this.
Very humbly, Milord, what I propose, Milord, I told my learned senior friend that he's an expert of this subject.
No.
He knows how much time it takes for a direct purchase. May I please, sir? Milord, I said the minimum time required to, Milord, undergo a direct purchase, I'll do it by that time. Please tell us the time, sir. Within what minimum time?
Time will be calculated from the date of the order. If today you coerce somebody to sign,
if I have coerced, Milord, I do not
then
have
you
anything
do
to
not-
say before. I
you
cannot
cannot
utter a word before your lordship.
You cannot take today to be the time which will start only for the direct purpose purchase. It is the court's order of 2020 and you are to comply. It is as simple as this. Whether direct, whether the act, whatever it is, the court requires an affidavit of compliance. Please come. And the court will be constrained to pass rule if the order is not
I follow,
complied.
Milord, I follow, Milord.
Because I do not have an alternative.
Milord, I follow, Milord, how this honorable court functions.
Yes. They let them do whatever they want within 1 month. I will come back after 1 month, but not in the process.
The order of the court is yet to be complied. Stop. The appeal preferred against the order stood dismissed and the same is yet to be restored. Stop. The under such circumstances, the contemners would be bound to file an affidavit of compliance. Stop. Hearing of the contempt application. Now, on the prayer of the learned advocate representing the contemners, hearing of the contempt application stands adjourned till 7th August 2025. An affidavit of compliance shall be on place on the adjourned date.
Obliged to your lordship.
May I take back that letter or?
Yes, you can take it back. The court has not recorded it. Take it back.
Well, I'm very grateful, Milord.
Like they have now taken instruction.
Yes. Anybody there for the petitioner? Dismissed.
I am for the petition.
My lord,
Yes.
I am appealing for the Jila Porishad, my lord.
But on the last occasion, my lord, they had submitted a report, my lord, with respect to the unauthorized construction. My lord, this matter had gone up on appeal. My lord had been pleased that this matter should also be heard at length, my lord. So I'm just.
It has gone up in appeal.
It had gone up, then my lord, it was.
Had gone
Yes,
up.
yes, it had.
And then it has again come down.
Yes. So,
And
my
your
lord,
lordship wanted
Finished
to
it over there.
Your lordship fix this matter today for finishing the.
No possible. It's just not possible for hearing. What is to be done?
my lord, in that case, my lord, I believe, my lord, all the unauthorized portions have already been, my lord, demolished as per that report. My lord, if
Not
they have
that,
any,
my lord, not that.
very well, my lord.
Not
So, my lord,
So, but they cannot. My lord,
My lord,
make standover.
my lord, it is not the report of Jila Porishad. It is the report
This
of the
cannot be, my
committee
lord.
formed by this Honorable High Court, the state's representative and the Jila Porishad representatives are there. My lord, they are saying, my lord, unauthorized portion has been demolished. My
Has
lord.
been demolished.
My lord, I have brought the picture also, my lord. Report is my lord, today, my lord, I have brought pictures, my lord. My lord, if your lordship.
But your lordship.
What is your proposal? I want to hear what the petitioner has to say.
But
The fact remains that there are unauthorized constructions which
Yes.
cannot be demolished further.
But
It cannot be demolished further as per the report of the authority.
whatever
What
may-
is to be done?
well, my subject was of consideration.
Yes.
Your lordship passed order in the writ jurisdiction.
Please do not
Now-
go back to square one. The court is aware.
Now, my lord, the portion, the unauthorized portion has not yet been demolished.
That
Part has been
portion
demolished.
cannot be demolished because if that is demolished, the entire construction has to fall down.
Now, my lord, may I submit?
Yes.
But out of 24
Pillars.
they have constructed illegally 16 pillars. Now the risks, they have taken the risk to construct illegal building.
Yes.
But they have constructed double the sanctioned plan.
Right.
So now, my lord, I am asking a question to myself. But
What are they doing in that building?
they are the commercial building, commercial and also residential.
Commercial and
Commercial also
residential.
residential. My lord, can see there is no plan for mezzanine floor. They have constructed this more than 2,000 square feet. But they have not even leave any space from the other building. They have constructed this. 16 pillar has been constructed, but entire construction more than more than double construction made. Now it is their risk they have constructed, and your lordship knows better than me. The Supreme Court time and again says that the order passed in the writ jurisdiction cannot be altered and modified. See, your lordship's order has not been appealed against nor reviewed.
No, appealed and the appeal court has
Then
remanded
the appeal
it
court
back.
appeal is against the order of contempt. They cannot.
Oh, against
Yes,
not
yes.
the writ court
No,
order.
no, my lord. Against the order, interlocutory order passed by your lordship in a contempt jurisdiction. That's why Justice
The
Bakshi, my lord, returned the matter to your lordship.
Appeal court order was the writ court's order was not challenged.
No, not at all. Not at all. So, my lord, I have brought the number of citations so I can praise this matter.
No, I can understand.
Your lordship knows this. So they cannot go.
You all are standing in a very precarious position and the entire construction is to go.
Yes, my lord.
If the order of the writ court still stands.
Yes, my lord.
Very well, Lord, we'll try and, my lord.
What is their local standing to appeal, my lord? They are the private parties.
No.
Who is the authority?
Authority is there. Panchayat and
Construction by the private parties.
I'm accused of making. I'm accused of making the construction.
They intend to file an application for additional party before your lordship.
No, because they are the persons responsible for making the construction.
Yes.
So I'll hear them. Their property will be demolished.
Well, I am not to stand on the way.
Yes.
Your lordship.
No, that is all right. But then, what is your stand?
My lord, basis, my lord, my lord, what has happened over, my lord, before the division bench, my lord, there have been certain orders, my lord, to some extent, this stands on a peculiar footing, not like the usual other matters, my lord. So, my lord, this will require me to place some orders and all, my lord, so that. My lord,
the unauthorized construction means.
Well, my lord, I will try.
My lord, also.
My lord.
Yes.
The report of the experts say that unauthorized construction is there. But then if anything further is to be demolished, then the structure which has been constructed as per the plan also
and the adjoining
will go.
My lord, this has a peculiar factual situation because certain observations were made there, certain reports were filed. That is why, my lord.
Thing is, there is a plan and you have to construct accordingly. There cannot be anything in between beyond that. Nothing beyond that.
My lord.
What is your submission?
My lord, I'll come back after a fortnight, my lord, with some, my lord, instructions on this aspect.
What are you doing in that property?
My lord, ground floor, my lord, what is there? My lord, that is where I want to also take some instructions. My lord, there are certain shops which are there, some medical shops, ground floor. That's what I can find from that. My lord, I will further take instructions. I'll come back after a fortnight.
Please come.
The instruction they are carried বাড়িতে আন এবং কোনো এর বিষয়ে কিছু করা যায়
Learned advocate representing the persons responsible for making construction. No, আপনি লিখুন learned advocate representing the persons at whose instance the unauthorized construction was made seeks time to come prepared.
I'm not essentially take instructions on that aspect.
Seeks time to take further instruction on such prayer. Released the matter on 17th of July. But then the court has made its mind clear that if there is some unauthorized construction, it has to go.
My lord, I'll try and, my lord, submit, my lord, some reports of the division bench and all, my lord, because of the peculiar trajectory of this matter, my lord. I'll have to, my lord.
Next.
Be grateful, my lord.
79.
My lord, I am appearing for the petitioner.
You are for the petitioner? Yes, please.
Lordship, I am appearing for KMC.
Yes.
My lord, there is a very small point for which this application for amendment of the order is for revision of the order, modification of the order. My lord, may kindly see the para 3 of the CAN application.
Lordship, actually, we haven't get a copy of CAN application. Kindly direct them to serve a copy.
We have served, my lord, we have the affidavit in service. It was served
How-
by hand to the council representing the.
To whom? Who has received it? Check up the signature, please. Who are you representing?
I led by Miss Seema Chakraborty.
For the corporation.
All those who had appeared.
Did anybody receive for the corporation?
All, yes, my lord. All three
received?
have appeared. Mr. Barin Banerjee, advocate for KMC, Miss Seema
Miss-
Chatterjee.
Mr. Banerjee took a copy of the brief and you say you've not received it?
Lordship, might be it in the department. Lordship, we haven't get a copy in the.
It was handed over to the advocate, my lord. The receiving is by hand by the.
It was not to the department. It was addressed to the learned advocate and the clerk has received it.
Lordship, kindly.
1 minute. Just wait. Possibly Mr. Barin Banerjee has not received. Has he? Possibly he has
On
not.
behalf of them, my lord, they
On
have.
behalf of the state, it has been received, not on behalf of the corporation. Give a copy to her.
Grateful.
Let a copy of the application be served upon the learned advocate representing the corporation. And what is the modification that you are seeking?
Only, my lord, it has been recorded that common space we are seeking it for an open space.
They are
As
not proceeding with
the illegal construction which was on the particular portion of land, my lord, it is recorded that it is in a common space, which is abrupting a passage which is abrupting the ingress egress of the petitioner. As per the report of the KMC, it is that it is not a common space, it's an open space, which is where the construction lies. So because of this word change, my lord, they are not complying with the order saying that come to us with the specific word direction that it is open space. So on that short.
Common should be replaced with the word open.
open space.
Is this the only?
That is it.
From common.
Where is the report of the corporation? Was it filed?
There was a stop work notice, my lord, which is annexed as Annexure B in this application, my lord. And they have orally stated to the petitioner that we will not consider because of this, pointing that out in the order, my lord.
This comes at page number 10. The work stop order. What we had pleaded, my lord, and what was there by the KMC at that point of time, relevant time, was a common passage. So that was recorded in the order. Now, my lord, they're saying that it's an open space and that's why we'll not give it.
Listen, the word common was recorded in the order as that was the instruction of the executive engineer.
Yes, it was, my lord. Now they are saying something else, my lord.
So that is not the lookout of the court, and for that you'll go on for amendment.
My lord, as per their current report, they're saying that we have made another
The
inspection.
order was passed
6/1/2023.
on January 23. Today we are in 25, right? As things were there on that date, court passed order. You cannot come up with an application for modification today and say that the facts have changed.
It was filed long time back, my lord.
It is not a matter of filing. The order was passed on the report which was filed by the corporation. Now, if corporation changes its stand, it is their lookout. It's not for the court to go on changing and modifying orders.
My lord, they are saying that the report as per the recent inspection, it is coming now. The same area is coming now as an open space.
Sir, the court is not accepting your prayer for modification. Did you get it?
We can come with a fresh writ petition, my lord.
It's up to you. What you will do, the court is not here to advise you. Please come. The petitioner না কি ওটা থাকবে সার্ভিস করে দেবে The petitioner prays for modification of the order dated 6th January 23. It has been submitted that in the order dated 6th January 23, there is a recording of existence of GI shed over the common passage. Stop. Learned advocate for the petitioner submits that at present the common passage does not exist, and the expression common passage is to be replaced by the expression open space. Stop. On a perusal of the documents in file, it appears that a report was filed by the executive engineer within brackets Civil Building Department Borough 3, signed on 2nd December 2022, clearly mentioned 2 GI sheds were observed covering the common passage. Stop. Relying on the instruction by the engineer of the corporation, the expression common passage was mentioned in the order. Stop. Whether the same is currently an open space or not, no. If currently the common passage has changed to an open space, comma, the said subsequent fact cannot be a ground for modification of the order which was passed more than 2.5 years back. No, nearly 2.5 years back. Stop. Next. In view of the above, the prayer of the petitioner seeking modification of the order cannot be accepted. Stop. The application stands dismissed.
Grateful Lordship.
Affidavit of service taken on record.
Grateful Lordship.
It is your name that will be recorded in the order and nobody else's name. যারা অ্যাপিয়ার করবে কোর্টে তাদের অ্যাপিয়ারেন্স দেবেন, যারা
The hearing was fixed on 5th of July. Kindly adjourn for my lord 2 weeks.
Which one? 80? All right. On the prayer of the learned advocate representing the petitioner, hearing of the contempt application stands adjourned till 24th July.
I beg to appeal. My lord, my lord, past order dated on 10th of April 2025 explaining them to the delay for compliance of my lord's order. They have
Yes.
filed a report, affidavit,
Lord,
admitting
the
that
reason for the delay has been explained, my lord. Since there was a shifting of the department from one floor to another, my lord, the bundle which was containing the records, my lord, got misplaced. My lord, upon receipt of the contempt notice, my lord, they again then, my lord, tried searched out the records, and my lord has lordship's order has
And
been.
what is the period of delay?
Yes.
2 years.
2 years?
Well, how they
Not
have explained-
exactly 2 years.
How they have explained, kindly come to paragraph 4 and 5.
You are the municipality?
Lordship.
Yes.
My lord has specifically, my lord, asked to my lord to explain the delay. Right?
Lord, in paragraph 4, 5, and 6, my lord, the delay has been explained.
July 10, no? 10th of April. Order, my
Admittedly,
lord.
my lord, there was a delay.
21 order was passed and it was communicated when? 23?
No, order
On
order was
2023.
passed on 20th February 2023.
Order was passed in September 21 and you communicated in 23?
No.
You communicated in 21?
27 I communicated. 27 order dated 20th February 2023. Communication they have received on 28th February.
From the contempt, please show me when you communicated the order.
Contempt application. They admit in the affidavit, they have also admitted. Para 4.
Oh, February 23 and in February 20.
Order of 20th
27 February 2023.
The letter was of 27th February and they have received on 28th February
28th of
2023.
February.
My lord directed to
No, no,
comply
it's not
within
right.
3 months.
Yes.
So they have explained in para 5.
And when did they comply? In 25?
No, 25.
Lordship.
28th March 2025. Exactly 2 years. And how they have explained? May I read for my lord para 5? Usually records.
Not the
which
contempt
button-
application was received by the municipality on 11th of March 2025. Then
It is not a matter of receiving the contempt, you are aware. How do you propose to justify this stand? Who is the contemner?
Chairman.
Chairman of the municipality?
Yes. Chairman.
And what was the chairman supposed to do? Consider the representation.
Yes.
Unauthorized construction. Has unauthorized construction been detected?
My lord, they say, my lord, there was an extra floor, but it was regularized upon giving
the order
occupancy certificate. This was
order is at page 5 of the my lord compliance affidavit.
May I read, my lord? Third paragraph from bottom. It appears from the inspection report dated 21st March 2025 that flat measuring about 185 square feet exists in the 5th floor of the building. Building plan wide number such and such dated such and such was sanctioned for 5-storied building. After above the 5 stories building, a 5th floor has been constructed. It is also appears from the said inspection report that occupancy certificate wide number dated such and such was issued in respect of the building situated at plot number such and such by this office. It also appears from the office record that this said flat was regularized at the time of issuing occupancy certificate. and the said flat is recorded in the assessment register against the holding such and such. How they can regularize, my lord?
How they can regularize is a different
Yes,
question.
yes, my lord has
You can
granted me
leave,
liberty.
you can, yes.
I can.
But there is a delay in compliance,
Yes.
and how can you explain? I am not satisfied with the explanation.
And my lords may kindly keep.
The court is not satisfied with the explanation of delay.
My lord,
Some amount of
Your Lordship, kindly
punishment
consider,
has
my
to
lord.
be imposed.
My lord, your Lordship, kindly consider, my lord.
I have seen that.
Yes, my lord. My lord, that is the, my lord, actual fact, my lord.
Yes.
The files were misplaced, my lord.
Right.
My lord, when the municipality got the application for contempt, my lord. Your
Then
Lordship,
only they woke up and then this order has been passed.
Your Lordship,
Now,
can you
what
see
is
that
to happen for the period that the municipality missed the file? Something has to be done. What? How much
Your Lordship,
cost?
Lordship, kindly, my lord, do not impose the cost, my lord.
Why not?
Your Lordship, kindly, my lord.
Why not?
My lord, it is admitted that there is some latches, my lord, on the
Yes.
part of the municipality.
Right. This is the reason cost is to be
Not
imposed.
intentional, my lord. Your Lordship, kindly consider. There is some latches, but not intentional. Your Lordship, kindly consider, my lord.
The court will consider. This place in the Damdam area.
South Damdam.
South Damdam. You plant some trees in your area.
Yes, my lord.
How many trees will you plant?
I do not.
All construction made.
Illegal, legal,
My lord,
regularized, occupancy certificate.
in spite of that, my lord, so many trees are there also, my lord.
You plant more trees.
Yes, my
Where
lord.
will you plant? Within your jurisdiction.
My lord, places are there, my lord.
Identify places.
Some parks are there.
Yeah,
my lord.
identify places and bring the list before this court.
Yes, my lord.
All right.
Yes, my lord.
And planting trees to the tune of rupees 10,000. Not more than that.
No,
All
no,
right.
my lord, no, my lord, not 10,000, not
10,000 rupees
not
plan.
10,000, my lord, your lordship.
No, it is plans. You are not giving
my
it
lord,
to the petitioner.
My lord, your lordship.
You are not giving it is for your constituency that you are doing it. So
No,
do
no,
it.
my lord, your lordship, kindly consider, my lord, not 10,000, my lord, your lordship, kindly consider.
The petitioner has perused the affidavit filed by the contemnor explaining the delay in complying the order of the court. Stop. It appears that there has been the court is not satisfied with the explanation. Stop paragraph. The court accordingly directs the contemnor to identify places within the jurisdiction of the municipality where trees can be planted to the tune of rupees 10,000.
Your lordship, kindly consider, my lord.
Let the places identified. Now, let the plan as to how the trees will be planted, how and where the trees will be planted, be placed before this court on the adjourned date. 17th of July.
Your lordship, kindly reduce
The
the
Roth,
amount, my
the
lord.
Roth festival is a very good time for planting trees.
Yes, yes, my lord. My lord.
So you please take it up.
My lord, on behalf of the municipality, my lord, on behalf of the municipality, my lord, on behalf of the municipality, my lord,
It is your
my lord.
municipality.
Yes, my
You
lord, your
plant
lordship,
trees.
kindly reduce
Nothing.
the amount, my lord.
No,
Your
no,
lordship,
no.
kindly, my lord.
You are the municipality. You are not a private. You are not a pradhan. You are the municipality. You are stand at a better footing.
My lord, may fix the quantum of numbers of trees because
Let them
nobody knows they will
I
purchase a
understand.
tree in 10,000.
I understand. I am passing regular orders. Please wait.
82, my lord, I am appearing on behalf of the petitioner, my lord. Last occasions, my lord, municipality pray for an adjournment, and your lordships was directed to produce the copy of the report. My lord, they have not produced any report.
Affidavit of compliance, please.
My lord, Mr. Arindam Das is appearing in this matter, my lord. Due to some personal difficulty, he could not come down today. My lord, kindly give me 1 day accommodation. My lord.
Last day also 1 day accommodation was given. Today also 1 day accommodation.
As per instruction, the spot inspection has been completed.
Bring a report before this court.
My lord, for this reason, I just praying for accommodation, my lord. My lord, kindly.
Every day accommodation cannot be given. This is the difficulty. Because the list is being stalled.
I have soft copy, my lord.
Why don't you take a printout and hand it over to your learned friend? That will help him. He also gets to know.
Affidavit is not completed for this reason, my lord. Kindly give me for
15th of May and today is 25th of June. So I'm going to direct your client to be present in court. All right? Likhunto, affidavit of compliance has not been prepared till date. Stop. The matter stood adjourned on the last occasion on the prayer of the contemner. Stop. Today, similar prayer for adjournment is being made. Stop. The court is not inclined to
I will complete it and file it.
adjourn the matter any further. Stop. The contemner number 1. No, both the contemners. The contemners
Completed, my lord. My lord,
are directed to remain virtually present on the adjourned date. Stop. The affidavit of compliance shall be placed in court with an advance copy to the learned advocate for the petitioner. Stop. Released 10th of July. Next.
In this matter, your lordship, I beg to appear for the petitioner, lordship. Lordship, in the last order.
Released.
What has been released? PPO.
PPO. In this
Are you aware?
Lordship.
Are you aware that
Only one
PPO has
thing-
been released?
No, no
I
communication.
have the copy of the PPO.
Your
lordship.
Virtual mode. That is,
Yes, give a copy to him.
PPO.
And on the last
And
occasion,
only one thing, Madam has directed me to file a compliance report that will be done within next week. PPO, I am showing that.
Give a printout to your learned friend.
I will give also, but I am showing
Please
also.
come. Learned advocate representing the contemner submits upon instruction that the PPO has been issued in favor of the petitioner. Stop.
আমি দিয়ে দেবো কপি
Let
পেপারটা দেখে নিন একবার।
an affidavit of compliance be prepared and served upon the learned advocate for the petitioner prior to the adjourned date. List on 10th.
The PPO dated is 26 June 2026.
That
25th,
means
26th.
26th.
25th June, sorry.
Yesterday.
Yesterday.
It has been
Already hearing done.
কালকের ডেটটা দিয়ে
Queries have been
has been issued
reported.
for
Our
the
officers
PPO
went
issued
there and got
on
it done, got it released.
25th
They are very
to
scared, my lord.
25. Yes.
Next week, my lord.
Following week.
Following. I will file a compliance report.
Yes.
Apply, lord. কত তারিখে থাকবেন?
For the petitioner, my lord.
কত তারিখে থাকবেন?
Appearing on behalf of state, my lord.
My complaint order has been complied with, my lord.
What order? This is demolition.
Demolition.
Dinesh Agarwal. Corporation is to say, my lord.
Bidhannagar. Yes. What is
On
it?
15th, Millard, your lordship has passed an order
Hmm.
directing the state respondents, Millard, to provide police assistance. Now, on the same date, it was our submission that without, Millard, eviction of the occupants, we cannot demolish. However, Millard, on 10th of June, we have gone to the site at 11 to demolish the thing. Now, Millard, the building was occupied. We could not demolish the unauthorized structure as per your lordship's order.
How
Millard.
big is the unauthorized construction?
Millard, 1 floor above the sanction plan and encroached, Millard, a open space area, side open space area, and 2 shops, Millard. So, Millard, the second floor, we have demolished the walls and we have made some holes in the ceiling. I have, Millard, the action taken report, which is, my lord, signed and prepared on
Without the photographs, why are photographs not given?
My
Seek for photographs next time. And
that photographs I have, if your lordship so desires, I can place it before your lordship in
the screen so that the petitioner can see.
Kindly allow me a second, my lord. Okay. দেখাও।
No, no, permanent.
না, 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 ওটা না, ওটা না।
Put it on the screen so that the petitioner can see at least.
Side open space টাই কর।
Side open না, 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 এখানে পাঠিয়ে দিই আমি। এখানে পাঠিয়ে দিই চট করে।
Are you aware of any such demolition?
Yes, my lord, this mandatory side open spaces have not been, my lord, but he is correct, my lord. The holes have been made on the first floor, my lord.
Right.
And the shops, my lord, the garage which has been now turned into shops, my lord, those are also
still there.
My lord, they, my lord, denied to vacate, my lord. Kindly peruse my action taken report, the last paragraph, my lord.
Very well. Please come. The action taken report prepared by the engineers of the Vidhannagar Municipal Corporation.
নাও না তুমি পুরোটাই নাও। আচ্ছা পুরোটা নেবে।
In June 2025, filed in court, is taken on record. It appears that certain portions of the unauthorized construction have been demolished. Stop. The other portions could not be demolished as they are occupied. Stop. Paragraph. The police of the Vidhannagar Police Commissionerate is directed to vacate the unauthorizedly constructed portions using reasonable force so that the same may be demolished. Stop. Paragraph. The occupants in possession of the portions constructed unauthorizedly are restrained from interfering with the process of demolition. Stop. The CESC Limited, who provides electricity over there?
WBSIDCL.
Electricity.
WBACDCL, my lord.
The electricity service provider, CESC hobe na. The electricity service provider is directed to forthwith disconnect electric supply to the portions constructed illegally. Stop. The Vidhannagar Municipal Corporation shall disconnect the water supply to the portions constructed illegally.
But if any, we usually don't.
Even my lord, the occupiers, this is no, occupiers are not entitled to stay there. They are not the leasing.
Achha.
Please come to the first page of my report, my lord.
Please tell the police not to decide as to who is the lessee and who is the lessor. Let them only go and comply the court's order. They are not acting as court over there, right?
My lord, I am abide by the court only.
Right. So let the police not go and act like court officers over there. The police doesn't know where to draw a line. At times they become inactive, and at times they become so very active that the court has to stop them. The date of demolition shall be intimated by the corporation to the police so that the vacating can be done simultaneously. Now, police stop kore din. Police stop kore din. Even likhun, the vacating and the demolition of the unauthorized construction shall continue simultaneously. Stop. Release the matter for further consideration on 7th August 2025.
The photographs that I have given on the screen, my lord.
Show it to him. The court is not concerned.
Deeply obliged, my lord.
Yes. Yes.
The applicant in the can number 1 for application for intervention, my lord. On the
In a contempt matter?
yes, my lord.
Lordship, I am on behalf of the applicant.
Sorry,
Lord.
I am for the contempt. I'm so sorry.
I am
Yes.
for the contempt. Lordship, I am on behalf of the applicant, Lordship.
Yes.
Lordship, on earlier date, Lordship directed us that whether for this construction any sanction plan is required or not, both parties are directed to show the rule, Lordship. Lordship, I have perused the Act, Lordship. In that event, I humbly draw your Lordship's kind attention on Section 2, Subsection 3 of West Bengal Municipal Act.
This is a municipal area?
Yes, this is municipal area.
All right. Yes.
According to Section 2, Subsection 3, the building means a structure constructed for whatsoever purpose or of whatsoever materials and includes the foundation, plinth, wall, floor, roof, chimney, fixed platform, veranda, balcony, cornice or projection or part of building or anything affixed thereto or any wall in this construction, Lordship. The wall is brick built wall. So Lordship, now Lordship, according to these ingredients, the construction is very much able to come within the ambit of building. Now, Lordship, I humbly draw your Lordship's kind intentness on Section 204.
What was your allegation in the writ?
Allegation is, Lordship, the construction is completely illegal construction. And Lordship, I filed the writ petition, and writ petition was disposed of in favor of the petitioner applicant. And Lordship, if the Lordship directed, if the illegality is detected, then the construction is required to be removed. And Lordship, after that, it is detected that this construction doesn't have any sanction at all.
Yes.
So when the construction doesn't have any sanction, then this construction is treated is tantamount to
There is a
unauthorized.
civil suit pending in respect of
Civil
the same
suit is
construction.
civil suit is pending regarding another aspect, Lordship.
Aspect.
Regarding eviction, regarding the purpose of eviction, but regarding the purpose of the demolition of unauthorized construction.
Eviction from the same place where the construction
Eviction from the same place, because not same place, because the unauthorized persons acquired my room also. My room also.
I didn't follow. The
unauthorized occupier,
Yes.
the private respondents in the main writ petition,
Yes.
they also acquired my room also.
The encroachment is a civil matter.
Encroachment is a completely civil matter.
Right.
Regarding encroachment, I lost a civil suit, and civil suit is decreed in
Continuing.
my favor. Execution is pending.
Whatever. It's all
Whatever.
right.
But regarding illegal construction, on earlier date, Lordship was pleased to point out that regarding illegal construction,
Yes.
regarding illegal construction, what step has been taken by the municipality?
Right. What is the stand of the municipality?
Well, there is no construction. Well, if your lordship turn to the
You have given photographs to show that
there is a
construction.
whole structure. Well, kindly see the paragraph 6 and 6A of the writ petition. They are occupiers.
Old structure is not required to be obtained.
Only well, a new building and re-erection as per section 205 and 204A. If a person is going to construct a new building or reconstruction of the floor, then permission is required. It is the old construction. This structure belong to them.
If it is his structure, he wants it to be demolished.
No, my lord. He already filed a eviction suit. Eviction suit is pending.
We will not go into the civil issues. We will consider as to whether there is any unauthorized.
Their allegation is the private respondent are, my lord, constructing a house there, but there is no construction, only repairing of tile shed. I have already detected, and your lordship direct me to inquire the matter and dispose of the representation. Kindly see the representation and kindly see the structure.
I can see the structure.
The old dilapidated structure. No new construction is there.
Maybe not be new.
Yes.
Old construction, when it was made, Was there no requirement of taking a sanction?
At that point of time, my lord, there is no question because they have not, my lord, prayed for them. But they prayed that private respondent are going to construct a building. Where is the building, my lord? No building there. They are deciding there. They inducted. The civil suit is pending for eviction. In the meantime, they, my lord, abuse the process of law, my lord, before the municipality to demolish the structure, old structure. This tile structure is there, my lord. Kindly see. At that point of time, no new construction, no re-erection. Totally, my lord, abuse of process of law.
Either you are not following the court or there must be some problem.
No, we have no problem because the private respondent, the unauthorized occupant.
Query of the court is
Yes, my lord.
whether any sanction was required to be taken at the time of making the construction or not.
Yes.
Whether any sanction was required to be taken for raising the construction, photograph of which has been annexed with your affidavit.
Construct, my lord, permission is required under section 204A for new building on reconstruction. But here,
Again,
my
you are going to somewhere else. You have annexed a photograph where a structure is there.
Yeah.
Was the requirement of law such that a sanction had to be taken for making that construction?
Yes. But
was that sanction taken?
No, no sanction is in respect of this building. This
Then
structure.
what is to be done?
This structure is the tile shed, my lord. Only wall shed, no foundation, no plinth, anything under, my lord, definition of the building.
The definition of building has been placed.
Yes, my lord. There is a must be foundation with plinth. There is no plinth or foundation. Only, my lord, tiles structure with, my lord, brick. Surrounding brick.
The brick walls, if there are brick walls, then it has to
Or
fall under
any
the
wall.
definition building.
My lord, I have submitted before your lordship the facts and law. If your lordship,
No, no.
your lordship kindly, my lord, decide. We have no objection because
it is not a matter of objection. Your stand is that there was no requirement of obtaining sanction.
Because my submission is, since it is not a new construction.
New or old is not the thing. An illegal construction remains illegal despite the years that it
Illegal
is there.
construction made by him.
Who
earlier.
makes it is not important. Who made it is not important.
But
if it is his construction, he says it is illegal. Go and demolish it. What is
no? He has not paid for. He paid for the private respondent is going to construction a building. This is the problem, my lord.
Sir, there is a problem either with you or the court. I do not
kindly decide it. My lord, municipality, my lord, submitted it and inquired the matter. There is a civil suit pending for eviction, and the during the pendency they came before.
Had submission made on behalf of the parties. List for further hearing on 17th of July. Yes.
Well, in this matter, I apply for the alleged contemners. I'll be requesting to Lordship, my lord, to please move which time because certain papers have come. With reference to your Lordship, I'm totally confused with the papers. I could not assimilate, my lord. What is the
You are confused. I don't believe.
with the papers which has been given to me with reference to your Lordship's order? Your Lordship's order is perfect. There is no difficulty. But the papers which have been handed over, but I could not assimilate the how.
What was to be done?
Well, your Lordship, 2 weeks time, let me have a.
No, what was to be done?
Well, your Lordship directed that if any representation is made.
Is it an issue of unauthorized construction? Yes.
Your Lordship said if any representation is made, your Lordship details on other issues, your Lordship consider. Your Lordship did not enter into the other aspects. That one paragraph is there. Your Lordship directed to representation made that shall be considered in accordance with law. That is the issue on a whole.
May I?
Yes, please.
Hearings were conducted. Thereafter, it was asked on our part to submit written submissions that we have done. On the last occasion, submissions were made on part of KMC that order has been
passed.
Yes, order has been passed. Such submissions were made on the last occasion. But till now, we have received no notice on that.
No, I have got. That is the reason submitting. Your Lordship orders are long back. Now, I find an order that is also of the special officer building. That is order dated 21st of March 2025. Possibly my name is speaking about that part of the order.
No, I'm not speaking about that order.
What order?
I see a demolition sketch plan was prepared. Section 401 was sought to be initiated. Thereafter, what happened?
Well, that is an submitting, my lord. That the papers which is been given to me, my lord, that I find, my lord, the 21st of March 2025, the special officer building, my lord, passed an interim order. That is also I not find it's an interim order. Interim order stage. And then, my lord, they say that once he said that two issues are there. There are two options open to the resolve the matter: to demolish all the structure or regularization of the structure without sanction. That's the interim order, I find. Order of the Honorable Court will be followed by the department. Demolition sketch bill or a drawing is part and parcel of this order. Any person aggrieved by the order, 400 subsection 1 may appeal against this order to the municipal building tribunal. This order of the interim order was placed before the mayor in council. I don't think it could be said to be a final order even. That is the reason I'm telling you, madam, what way they have dealt with the matter.
That means it is still pending.
Still pending. Then they say that anybody could prefer an appeal also. How could they say that?
It is your officer.
But that is the reason I'm submitting to you. I know this officer.
When was the order passed? Order was passed.
Interim order to 21st.
Not the interim order, the court passed order.
Passed an order long back, I find.
July 2023.
Well, 23, 2 years passed. So your officers will be taken to good
one
task.
submission, Your Lordship. This interim order, the applicant herein, he has made an application for additional party which has not been allowed. This applicant has challenged this interim order before this Honorable High Court, and the Honorable High Court passed an order saying you go before the KMC. Thereafter, hearings were conducted. Thereafter, we submitted the written submissions. Thereafter, this matter was taken up on the last occasion, and your advocate for the KMC submitted that order has been passed.
And the appeal before the tribunal, is it still pending?
He said High Court. He said in the High Court case was filed by them.
No, that has been remanded to the tribunal. What is the submission?
Notice has been served on us.
The tribunal, matter is before the tribunal. Why see? I think.
Lack of communication.
That is the first blast I submitted to you.
Yes, madam, the proceeding before the special officer was concluded.
Concluded? Where is the final order?
The final order was not provided on the last day. That is why the lawyer, my learned friend appearing on behalf of the KMC, submitted that they will find out this and they will come back today, my lord, on the next date of.
They have not found out. Yes. Are you aware of the final order?
Well, they did. I find.
How? Which order did you challenge before the court?
I have never challenged any. I have not got any order till date.
The interim order, Your Lordship. The interim order.
Interim order you challenged.
While Milord appearing during the hearing before the special officer.
By the way, why will your application be taken up for consideration in the contempt matter?
My lord has already decided that the application will not be taken into consideration.
The application will not be taken up because Milord, I was the party, Lions Orthopedic Hospital. Initially, it was the writ petition was filed against me by the petitioner. It was decided on the merits, and it was dismissed. Only one paragraph was left upon the petitioner to make a representation before the KMC. Thereafter, they came up with the condemnation and the proceedings are were continuing before the special officer. On the last.
No, but then here you do not have any role.
Not complete.
Please come.
To come back with the report.
I won't allow you to continue. An application for intervention has been filed.
Well, the property, I am enjoying, Milord. This was gifted by the petitioner's late father, Milord.
They are the ones responsible for the unauthorized.
All the merits are already decided in the Milord writ petition. That is all my submission.
The applicant seeking intervention was already a party in the writ petition. The writ petition stood disposed of by the court on 7th July 2023. Stop. The applicant's submission was duly considered by the court at the time of hearing of the writ petition. Stop. At this stage, the court is not inclined to in a contempt proceeding. The court The court ensures compliance of the direction passed by the court. Stop. The presence of the private respondent may not be required at this stage. Stop. The official respondents have already entered appearance and will answer the query of the court as to whether the order of the court has been complied or not. Stop. On the prayer of the learned advocate for the contemner to take proper instruction, release the matter once again on 10th of July. Stop. The application stands dismissed.
My lord, I am appearing on behalf of the contempt. I think unconditional apology to the court, my lord.
The earlier order.
Court, my lord, order was not till that was complied with, my lord. Today itself, my lord, one inquiry is going on, my lord. I can assure the court, my lord, within 7 days that order has been will be complied with, my lord.
The very fantastic matter only for dragging this matter. When a lordship fixed the matter today, they have noticed the issue, my lord, only for holding the inquiry.
No, I'm
last
accepting
occasion,
that, my lord.
last order kindly see.
Which authority?
Municipality authority.
Contact municipality.
Contact municipality.
Today's inquiry is going
Very
on.
fantastic. Lordship last occasion, lordship passed.
The order of the court is yet to be complied. Stop. Learned advocate representing the contemner seeks extension of time for compliance of the same. On such prayer, released on 24th July, stop. An affidavit of compliance shall be prepared and circulated prior to the
Otherwise,
adjourned date.
I will be retired from this matter, my lord. I will not present this type of contempt.
I'm for the petitioner, my lord. In the earlier occasion, lordship directed the Association Municipal Corporation to dispose of the application of the petitioner on 12 February and to circulate the complaint report on 13 March. Hearing concluded, but nothing has been given to the petitioner. What is the fate of this hearing?
My lord, hearing concluded, but we require some more documents. We have fixed another hearing on 30th June. After verifying the same, my lord, order will be passed.
Please come. It appears from the submission made on behalf of the parties that the authority, which authority is it?
Asansol Municipal Corporation.
That the corporation is in the process of complying the order of the court. Stop. Some time has been sought for complete compliance of the court's order. Stop. In view of such submission, release the matter on 24th of July. Stop. An affidavit of compliance shall be prepared and circulated prior to the adjourned date. No.
89, my lord, I am for the petitioner, my lord. The application for restoration, my lord, I have served London State Advocate, my lord.
Let me see.
The last Thursday he was here. My read is for, my lord, for blacklisting without giving an opportunity of being heard. My lord, if
That is the merit of the matter.
my
But
lord,
then why was it dismissed?
my lord, I failed to appear.
You failed to appear. Then what is going to happen?
I filed an restoration. If my lord pleases fix a date, my lord, I may serve again to the state advocate.
Please come. The petitioner seeks recalling of the order dated 3rd March 2025. Stop. I have perused the application for recalling and being satisfied by the ground mentioned therein for non-appearance of the learned advocate on the day the matter was taken up for consideration by the court, recall the order dated 3rd March 2025. The writ petition is restored to its original file and number. Can disposed. list the matter in the combined monthly list of July.
I'm great.
আচ্ছা আরেকটা জিনিস, let further notice be served upon the learned advocate representing the respondents, intimating the order of the court.
I'm grateful.
So I'm for the petitioner. Also by, yes, last occasion I have served with a copy of the report.
My lord, may kindly peruse the report. My lord, this is the report from the district magistrate which your lordship has been.
What, 1 minute, what is your submission? Has the order been complied?
No, lordship, the order was demolition of the illegal structure because it was constructed under PMOI scheme, and lordship, the recovery of the amount. Now it is admitted 1,10,000 was given. Lordship, according to the report, till now 40,000 have been able to recover.
They will take steps for recovery, and they are taking steps.
Yes, my lord, the authorities are taking step. My lord,
Demolition done.
yes, my lord, demolition done.
Demolition is
Now, my lord, if my learned friend disputes, there is a leave from your lordship to file affidavit regarding details of the demolition. They have not filed. Now, my lord, it's a disputed question of fact.
No, has demolition been done or not?
So demolition done, but not a entire structure has been demolished, and lots of the debris is also not removed from this place because this is an agricultural land.
All right, they'll remove the debris. Please come. It appears from the submission made on behalf of the parties that the municipality, you are the municipality?
No, my lord, I am for the alleged contender number 1, the district magistrate.
Acha. Demolition done by whom? The municipality?
The order of your lordship that the district magistrate should
Yes,
get
yes.
it done to the concerned municipality.
Right. So the municipality has done it.
And my lord, I have submitted
That the municipality has taken steps for demolition of the unauthorized construction, and the DM is in the process of recovery of the amount paid to the person responsible for making the unauthorized construction, relying on the amount from the PMAY fund.
শুধু এই তো কন্টেন্ট চেয়ারম্যান
The district magistrate has already, and district magistrate is in the process of recovery of the entire fund, which was released in favor of the person responsible for making construction. Stop. The district magistrate is directed to ensure that the entire fund is refunded. Stop. The contempt application stands disposed of.
And lots of entire debris can be removed, lordship.
The DM shall ensure that the municipality removes the debris from the subject place. As it has been submitted that the land is an agricultural plot of land. Next.
একটাই কথা, ওটা না অ্যালিজ কন্টেম্পটার নাম্বার 1 হবে। আমি রাজস্বী বসু অ্যালিজ কন্টেম্পটার নাম্বার 1 হবে, চেয়ারম্যানের হয় নয়।
দিন বলে দিন।
I am for the Bali Municipality, my lord, led by Mr. HON'BLE.
I am for the petitioner, my lord. Restoration application along with my lord kindly delay condonation.
What is the review?
Lordship, and writ application regarding unauthorized construction. Order was passed by your lordship disposing of the matter, wherein due to certain submissions by the erstwhile advocate, few misconception was arised, and therefore some remarks was made which was adverse to the interest of the petitioner. That's why a review petition was filed, my lord. That was dismissed for default. I couldn't appear before your lordship. That's why this restoration application and a delay condonation application.
Do you intend to press the review?
My lord, in review, I'm being led by Mr. Shubhir Shanal. He is
Whoever is there, do you intend to press it?
right now.
Not now.
Yes, my lord. Yes, ma'am.
You intend to
Yes,
press
ma'am.
it?
Can 3 is for restoration, my lord, and can 4 is for humble condolation of delay.
Yes, what is your submission with regard to the
I am for Howrah Corporation. Bali Municipality is the main answering response.
all right. What is your submission with regard to the restoration?
Restoration, my lord, as your lordship, please.
Restoration is also delayed. The review is
days.
also defective because it is filed out of time.
A condonation application, my lord, has been preferred in respect of review also.
Review. In case of review, we have to file the affidavit, my lord.
The review will come later on. Please come.
Section 5.
The petitioner seeks recalling of the order dated 30th January 2025 এর আগে একটা বললাম না রেস্টোরেশনটা রিকলিং সেম অর্ডার করে দেবেন
Section 5 আছে।
ঠিক আছে দুটো ক্যান আছে ক্যান 1 ক্যান 2 disposed the review petition is restored to its original file and number
Stay application আর can want হচ্ছে
ঠিক আছে
can want হচ্ছে delay.
list the review for consideration on 10th July.
The Howrah Municipal Corporation is no use here.
My lord,
Bali Municipality is the main respondent. So our names may be
Stay there for assistance.
my lord, the section 5 in connection with the review, it is not served. Kindly done.
I will serve, my lord. Certainly, I will serve.
Next.
My lord, same situation, same prayer regarding another
Same order করে দিন
grateful, my lord.
But I am for the petitioner, my lord. The contempt application, lordship, during the pendency of contempt application, the contemptor had preferred appeal. That was turned down. If your lordship kindly, this is the order, my lord. The relevant portion, your lordship will be finding at page 6, paragraph 13 and 14. So this was all about with the appeal, challenging the maintainability of the contempt application.
তো দিয়েছে তো
Paragraph 13 and 14.
Discuss the judgment, my lord.
টাইম নাও না কোথায়
তুমি জানো না আমাকে জিজ্ঞেস করছো কেন? কিছু দেওয়া হয়নি, রিপোর্ট পর্যন্ত নাওনি, রিপোর্টও নাওনি, রিপোর্টও পর্যন্ত নাওনি, কথা বলে না তো এখানে সামনে।
Yes.
To contempt application I will submit, Your Lordship, on 6th of February 2025, passed a direction. Your Lordship, kindly have the order sheet of Your Lordship. Order date is 6th of February 2025. The entire dispute was pertaining to objection raised by the petitioners during lockdown, that in a haste, the state authorities, with the collaboration of private respondents, made construction over the common path, which is in CS Parcha. Your Lordship has already notified that this was a common path. Now, my Lord, suppressing that fact, entire things was done. We filed a writ application. Thereby, Your Lordship has made.
No, what is to be done now?
My Lord, just kindly see the report which Your Lordship has.
No report has been served upon me, my lord.
My Lord, kindly see the order dated 6/2/2025.
Yes, I am at the order.
Now, my Lord, kindly come to the report filed by the.
What happened, my lord?
Now, my Lord, may I submit, my Lord? I am on the report which Your Lordship has called for. Now, my Lord, may kindly come to the field status report filed by the BLLR, which Your Lordship has called for. At point number 2, I am reading. Whatever we have alleged in our writ application, that was found to be correct. My Lord, I am reading. Recorded status. RS plot number 683 with an area such and such. Acre was classified as Danga in RS Khatia number 3 against noting Jatayater Jonno. Your Lordship is on that. For ingress and egress under remarks column thereof. D. Thereafter, two LR plots 678 and 679 have found recorded with the reference to the RS plot number 683 in the finally published record of right, as well as in the present computerized land record, but the noting Jatayater Jonno for ingress and egress, as was in RS record of rights against RS plot number 683 under remarks column, is found missing. This was the thing done. Now next, against both the LR plot number being 679 and 679, since KB stage, that is from the initiation of LR operation to the present computer's land records. C. Now kindly come to the field status report. In field of 4-storied building under construction, ground measurement of which is 2582 square feet, that is 0.06 acre, approx, found in existence over the LR plot number 678 and 679, thereby encroaching 1355 square feet, approx, in the LR plot number 678, which is found recorded in the LR Khatia number 1 in favor of the collector government of West Bengal, and also in the name of the patta holder, namely Nimai Sankar Padial, such and such construction has been going on. Now, this we alleged in our writ application. During the pendency of the writ application, starting from the year 2021 onwards, entire things have been done. And I will show some list of dates. Your Lordship will be amazing to file what is being done. I will support my list of dates with the document. I'm just saying, Lordship, in 2017, this land was purchased by contempt number 2 and 3. In 11/9/20, name of contempt number 2 and 3 were inserted in the record of rights, and nature of land was changed, which Your Lordship is finding from the report submitted by the concerned authority. Now, my Lord, we sent several letters. Kindly, these dates are very important. During lockdown, 8/11/20, 9/10/20, 5/11/20, 6/11/20, letters sent to authorities about illegal activities of the land brokers about government land. Now, writ petition was filed during year 2020. Immediately before that. Now, my Lord, kindly see, writ petition was, the moment we filed writ application, the sanction was granted. Now, kindly see the memo number such and such. Now, my Lord, Your Lordship give direction on 27/6/2022 that my representation dated 5/11/2020 should be considered. Now, Lord, kindly see what had happened just after that. Within a 1 month, not within a 10 days, order was communicated to them. Notice of contempt was considered to them. On 30/6/2023, application for new construction of multi-storied building.
Listen, what is to be done now at the contempt stage?
Not everything has been completed.
Everything has been completed.
Keeping writ petition pending, even when a contempt application was served upon them.
The writ petition is still pending. The writ has been disposed of, my lord. Pending.
That Your Lordship's order has not been complied. They were submitted some false report
which
Whatever, then what happened? What is pending now? Is any writ proceeding pending?
Writ petition your lordship has disposed of. Your lordship was asked to consider our representation.
That I have seen.
You know what I am saying? I will take only one. The representation which was considered by them was not considered by them. We filed contempt application. They come with two compliance report by two authorities. Your lordship perused them and found that they have complied the order. But my lord, we shown by our reply to the exception to the report that nothing was done. They filed appeal challenging this contempt application.
You are repeating the whole thing. What is to be done in the contempt now?
The illegal construction should be broken down.
How could it be, my lord?
It was our prayer in the
How could it be, my lord? I'm the contemptor, present contemptor. That misleading. It was misleading from the court, my lord. I'm seeing you that I'm very much relying upon my, report. I'm the present Panchayat Pradhan.
Please wait.
They have all the entire records, my lord.
Whatever I have made submission, that are from records.
Yes.
Now, my lord, your lordship has filed from my writ application. My main grievance was that over public land, constructions are being made. Your lordship permitted me to give me representation. Representation was given. That was not considered. That was kept on an entire building in the meantime was constructed. Now, my lord, my prayer is that the report which shows that half of the land upon which the construction is made is pertaining to government land, that should be broken down.
Is anybody representing the BLLRO?
My lord, my lord, in this matter, I am appearing for BLL
Yes.
state, my lord.
What
My
is
lord,
the stand? Whether the land is a government land or not?
My lord, we have already filed the report, my lord.
Yes.
My lord, dated March 10, 2025, my lord.
Yes.
And my lord, exactly that is the picture of the land, my lord, as it has been filed.
It is plot number LR 677.
677.
Though classified as Danga, has been used as pathway at present in front of LR plot number such and such by the adjacent plot holders. Measured length of the plot number such and such. Such and such. Yes. What is the stand?
Field status.
Whether the land is a public land or not.
My lord, may I pray for an accommodation just to come back with a specific instruction on that from the concerned authority, my lord?
In field, a 4-storied building, ground measurement such and such found in existence over LR plot number such. They are encroaching LR plot which is found recorded in favor of the collector. 678. It is recorded in favor of the collector and there is an encroachment. This is the clear recording.
This is what I was reading.
My lord, so far as the 677 is concerned, my lord, it is recorded as Danga and it has been used as pathway. Now, my lord, whereas which is in front of 678.
Yes, 678 has been found to be recorded in favor of the collector and there is construction made.
My construction made, my lord. Construction is going, such construction has been going on as it appears from the record.
Very well, yes, you are the Pradhan.
Milord, what they are suppressing, Milord, they have the civil code decree. They have the common.
The civil code
They
means.
Milord. I'm telling you, 1 minute. Parial family sold them the
I am
property.
not concerned with any family. I want to see whether the government land is encroached upon or not.
There is no
Let
encroachment.
The families fight.
Yes, Milord. There is no encroachment, Milord. They have the civil code. No, Milord.
The order of the BLRO says
BLRO is a false record, Milord. They have
BLRO
it is the correction. Yes, Milord. Correction of record of rights is pending. They have, erstwhile landowners all submitted to the Panchayat.
Why are you so concerned with
No, I'm not concerned. Milord. What is the correct proposition of law? That is I'm telling.
What is the correct proposition of law?
Civil code decree. If it is not nullified, Milord, it stands finality in estate acquisition. That is my prime concern.
Here, the report is specifically that a recording is there in favor of the collector.
Yes, Milord. I'm telling you, Milord. In computer sheet, if you come, Milord, that they did not mention that which portion is which size. 679 also they are showing 8. It is their report. It is written report. Along with that, annexure is there. Computer report. Kindly come. I'm showing you.
Yes.
That is why I'm telling Milord, this is not a correct report. They did not disclose all the things.
if you come to that 679, my lord, that is now it is recorded in Sahadev Samanto, Pratima Ghoda and Biplab Ghoda.
Yes.
It is 8 decimal.
Right.
In top of that,
Yes.
8 decimal. Total land 683 is a 8 decimal, my lord. 679 also 8 decimal. 678, what is government land there? That is 4 decimal. How is it possible, my lord? 683, if it is derived from 683, if it is total land is 8 decimal, then it has to be 4 and 4. It is their report. That is why I'm telling that this report has not to be, there is, it is not sacrosanct report. That is my, I'm there from their report itself, I'm deriving these things. Top of that list, that quantum of that land is written. They suppressed, my lord, that there is a civil court decree. What was placed before that?
It is not important.
My lord, absolutely, my lord.
The court will see what the record is going. Civil court decrees, the parties are there to agitate before the civil court.
And not only
and
that,
you do not interfere with the private parties' rights.
obviously, I'm not interfering, my lord. What is
You
that?
are certainly interfering.
I'm not interfering, my lord.
Please come. The inquiry report of the Blockland and Land Reforms Officer, Khanakul to Hooghly, dated 10th March 2025, is placed before the court.
My lord, in this matter, I am led by Mr. Nirutpal Chatterjee, my lord.
It
May I
appears
please-
there from that a 4-storied building under construction is found over LR plot numbers 678 and 679. LR plot number 678 is recorded in the name of the collector in Khatian 1. And Nimai Shankar Paryal is the patta holder. Top LR plot number 677, though classified as Danga in the record of rights, has been used as pathway in front of LR plot number 678. Stop. The learned paragraph, the learned advocate for the Pradhan submits that the records relied upon by the assistant director and the BLLRO are incorrect. Stop paragraph. Learned advocate representing the state respondents is directed to take proper instruction as to whether as to the exact portion of the plot number 678. You are concerned with 678? 678 is recorded in the name of the collector. 10th of July. Have you followed what is to be done?
I did.
Because the submission is that the plot in question, which is said to be recorded in the name of the collector, is of 8 decimal. It has been bifurcated and somebody else is there, and it is recorded as 8 decimal. 8 decimal land cannot be bifurcated with 8 decimal. It has to be 4 or 2 6 or whatever.
It was taken note of clause C of my report. It says LR plot number 678 measuring an area of 0.4, not 8, my lord. Exactly.
Clause C, LR plot number 678 measuring, yes, is classified at Danga. That is 678, yes.
Recorded in collector's name.
That is the name of the collector on behalf of the, whereas the LR plot number 679 also classified as Danga, right? So I do not know whether it is, there is demarcation or not. One says it is a government land, the other says it's private land. Now it is you, the custodian, who has to decide which portion is government land and to see whether any encroachment by private party has been made on the government land. Over the government land, 678, 679, whatever. আচ্ছা আরেকটা জিনিস লিখুন তো, specific instruction shall be given by the authority, state authority, as to whether there is encroachment by private party over any government plot of land. This is the concern of the court, nothing else. Private parties, they are fighting, let them fight. The courts are there, the courts will decide. হ্যাঁ, যেগুলো মেনশন করেছে সেগুলো নেব, কিন্তু পাসওয়ার্ড ডেকে দিন।
Kindly include concerning the plot involved. Otherwise, my report will be wrong, Lord.
No, regarding you can go on a roving inquiry. The division bench has already given a caution.
Other matter not taken up. Next.
Regular matters will not be taken up.
Our instruction is very follow.
Lordship, I ask the finance department, file line before the principal secretary finance department.
Yes, that means it has not gone up to the cabinet. It is at the finance level stage. There are other parties involved. What is going to happen to them?
Lordship, there is only
who is leading you?
Finance department is only alleged contender here. Finance department is only party here, alleged contender.
Yes, I have to array rest of them party.
There is no other party, Lordship.
Assuming finance is a party, the order of the court is with regard to a policy to be framed by the state. It is not a particular department which is to come up with a policy.
According
right?
to Principal Secretary Finance Department.
Now it was passed in August 24.
Yes, Lordship.
10 months over. What is to be done?
Lordship,
And
they need more time, Lordship.
A better way is let them file a compliance report.
Yes.
After complying. In the process of compliance cannot be a compliance report. Please come. Learned advocate representing the contemner submits that the file is currently lying in the finance department and some more time will be required for framing the policy. 4 weeks time has been sought for. The court notices with concern, paragraph A, that the order was passed nearly 10 months back. A particular time frame was mentioned. Within which a decision ought to have been taken. The said time frame expired long back. The manner in which the contemner is proceeding appears to be in clear violation of the order passed by the court. To give one more chance to the contemner to comply the order passed, hearing of the contempt application stands adjourned till 31st July. An affidavit of compliance shall be placed before this court on the adjourned date.
Grateful.
Grateful. Appearance.
It will be taken up. It will be taken up. Give the number. 370? 377? 377. Kanahilal, file bar korben.
My lord, 412 I mentioned.
Yes.
My lord,
It will be taken up. Your other side is here.
My lord, he is not coming. He came at 2 p.m. I tried to, but lordship said that after.
Yes.
Well, I gave notice to him also.
All right. 400?
12. Well, just for restoration. Well, there is an interim order.
412.
412. Well, I gave notice. Well,
412. Very well. File bar korun. কোনটা বেরিয়েছে 412 দেখি
Well, it was dismissed on 17 June. The lawyer was not well, did not come to court. Malad, page 15, Malad, lordship will find. And the urgency, Malad, for doing inconvenience to your lordship is that, Malad, in page 10, lordship sees there is an interim order. Well, in terms of lordship's interim order, I participated in a tender. And now, if the writ petition goes, well, my tender process, I will also go.
It cannot be helped. I can see page 9, 1, 2, 3, 4, 5, 6 learned advocates. The matter gets dismissed.
Because advocate on record was not there, could
The
not.
court is not concerned. What were the other advocates doing? Can you shift responsibility or fix responsibility only to the advocate on record? What are the others for? Somebody may fall sick, no difficulty. The person will recover. But why will the court? What can the court do?
I can't justify anything, but for fault of the lawyer, the client cannot suffer. I cannot justify this.
The client cannot suffer. In that case, the matter will be taken up for consideration as per the convenience of the court.
Please, I'm requesting, lordship. The client, regular supplier, they will suffer loss, that is why.
In that case, payment of costs.
Cost, I'm agreeable. I am agreeable to.
Choose how much you will pay. And it will go to the bar association.
Lordship.
Choice is yours. The court will not fix up any figure. It is your choice.
I will pay 10,000 rupees.
Very well. Please come.
Kindly keep this as service, because.
Yes.
17 June 2025, page 50.
Petitioner prays for recalling the order dated 17th June 2025, dismissing the writ petition for default. It has been submitted that the advocate on record of the petitioner it has been averred in the writ petition that the advocate on record of the petitioners was unwell and therefore not present before the court. Stop. It appears from the record sheet that as many as 6 learned advocates represented the petitioners before the court. Stop. In the absence of the advocate on record, the other learned advocates ought to have been vigilant. Stop. Paragraph. The learned advocate submits that the writ petition may be allowed. The restoration may be allowed, subject to the petitioner paying a sum of rupees 10,000 only in favor of the Bar Association, High Court, Calcutta. Stop. The proposal of the learned advocate for the petitioner is accepted. Stop. The petitioner is granted leave to deposit the sum mentioned herein above in the office of the Bar Association and produce the receipt before this court on the adjourned date. Tuesday, 1st of July.
Well, the interim order may be restored, but at 1
I will restore it on Tuesday. Acha, the communication made by the learned
communication as well as the affidavit of service.
Advocate of the state respondents filed in court today be written with the records. Affidavit of service also written with the records.
Restore it. I will pay and come back.
Yes, I will. I will restore.
Item 238, I have mentioned in the minute.
It is my evidence of service pursuant to Lordship's direction. I've carved way back in March 2025. Since then, nobody is happy. This is the difficulty.
What was the direction?
There was a direction, my lord, to cause an inquiry and conduct a hearing. There was an alleged illegal construction of Parampot, hanging bridge over my pond. There was a direction.
Unauthorized construction.
Yes,
Please
nothing
come.
has been done.
The order of the court
Without
is yet
sanction.
to be complied. Stop. The petitioner presses for hearing of the contempt application. List the matter on 10th July 2025. Fairly at the top of the list. Stop. Let further notice be served upon the contemner. Pradhan. Yes. দেখো ওপর দিকে দেবেন লেখা আছে অর্ডারে
My lord, item 404, my lord. My learned junior had mentioned in the morning.
Yes,
Lord,
please
had
wait.
asked me to mention, my lord, the other
কোনটা
side is
ডাকলেন
there.
আপনি
318 and 19.
all right
318, my lord, I am for the alleged contempt. My lord,
This is regarding disbursement of pecuniary benefit.
kindly
Kindly take your lordship's order dated
right, my
7th
lord,
of
here my learned friend starts, my lord, pursuant to lordship direction passed on 27th of February to bring on record the FIR and the charge sheet and the 161 statement recorded by the IO that I have filed an affidavit in the department. But I do not know whether it has been tagged with my lord's record or not. My filing number is 4, my lord.
all right
I have also filed, my lord. I am alleged contempt number 1, my lord.
all right
And to my lord,
what you want your terminal dues
terminal.
and
As per
why is
lordship
it
direction.
why is it being held up
Held
But,
up due to made an allegation that one criminal case was pending during the service period in the year 2020.
all right
Now that whether my lord was in inquiry that whether that criminal case involved in my service or not, because a contract was made between myself and the complainant in respect of giving some job. Allegation was made. Now, my lord, was query was whether I have been involved in any my lord, criminal case regarding
may I,
my
lord,
service.
may I hand over your lord? May I hand over my copy?
let both this matter appear in the list on 10th July fairly at the top stop the affidavit in opposition filed by the
Supplementary affidavit.
It's a supplementary affidavit
Supplementary affidavit in
filed by the
My lord, the contempt number 1 as well as
contemner numbers 1 and 2 in the department on
my lord,
My lord, 28 4
find one, my lord, 20, perhaps on 22nd. But the filing number, but I shall supply, my lord, immediately. My lord.
Yes.
Let me ascertain from my
কোন কবে দিয়েছে সেটা একটু লিখে নিতে হবে
But I shall supply.
করে নিয়ে আসবে
My lord, alleged contempt number 1, my lord, filed on
দেখে নিন তাহলে
28th April.
বি না না
28th April.
হ্যাঁ be tagged with the file
I'm a 28th of April, my one, the alleged contempt now filed on 28th of
28 April 28th 28
28, my lord.
yes 20th ঠিক আছে
An affidavit of service.
yes service is taken on record ওই affidavit দুটোকে আনাবেন
জানি না তো রেকর্ডেড
আনাতে হবে তো
yes somebody else which one is yours which one 404
404, my lord.
আচ্ছা 377 serially ডাকুন 377 then
On the last occasion, my client was present. I prayed for dispensation.
18 and 19.
Very well.
Complied with the agreement compliance with it. Kindly do not dispose it off.
no I cannot dispose in the absence of the other side
I said, honey, do not dispose it off.
yes yes
I said, Millard, only I pray. Kindly, her personal appearance. I'm armed with the Millard affidavit of compliance, which I need to submit.
আচ্ছা ঠিক আছে the matter has been mentioned
Without Millard informing the other side.
mentioned as the contemner is personally present
Millard,
in
I'm
court.
told my junior has called, but it went on ringing, Millard. He did not respond.
Hearing a schedule on that the
Right.
finally the contemporary
May I have the liberty to file it?
Affidavit of compliance, please do. The affidavit of compliance filed in court is taken on record. Stop. Copy served?
No. Yes. No.
Acha. Copy of the same has been served upon the learned advocate representing the petitioners. Stop. As the learned advocate for the petitioners is not present today, comma, hearing of the contempt application stands adjourned till 10th July. Stop. Let a notice be served upon the learned advocate representing the petitioners. Personal appearance of the contemptor stands dispensed with for the time being.
Deeply obliged.
Yes, call the next one.
চলে যান।
404. 404.
My lord, in this matter, my lord, we have passed the demolition order challenging that they have the aggrieved party filed a suit before the Howrah court. It was dismissed. Subsequently, they have filed another appeal challenging that is pending. In the meantime, we have informed the police and went to the area, my lord. But the police said it is a completely the person is residing in the building, my lord. The police said in page 74 that there is no specific direction from the court, honorable court, that they can vacate the premises. For such reason, they cannot vacate the premises. For such reason, we cannot proceed.
The unauthorized construction has been detected.
Yes, my lord. The demolition order has been passed challenging that the aggrieved party filed the appeal before the
I have
Appeal as well dismissed.
all the
appeal is still pending.
No, my lord. What appeal? That is a non-est. What I'm saying, the statutory appeal has been dismissed.
Dismissed.
The statutory appeal, challenging that they have filed some appeal,
Yes.
which they are not proceeding with, just to show it that there is some proceeding.
Dismissed.
My lord, it is not possible. My lord knows how it is.
What is pending?
The other party had also filed a writ petition challenging our order of demolition before the Honorable High Court, which is pending before court number 3.
Challenging the order of demolition, a statutory appeal was filed, and again a writ petition was also filed.
Exactly, my lord. They are doing everywhere. My lord,
We have given the notice that we shall go for demolition. On the challenging that notice, they prayed for the leave before the Honorable High Court.
What is the nature of unauthorized construction? How big is it?
my lord, it's কতটা বড়?
আরে অর্ডারটা আছে তো অ্যাটাচ করা। It is page number 30. Lord.
Entire building is unauthorized.
My lord, across like a part of the portion.
Square
My
meter.
lord, here, my lord, will kindly look at the demolition.
6.72 square meter, page 34.
All right.
My lord will see what has happened. My lord, this.
Very well. এটাকে করুন তো. The order of the court is yet to be complied. Stop. List the matter. Is there any other party apart from you all?
My lord,
Contemptor
is there.
Let the matter appear in the list on 10th July, fairly at the top. Affidavit of service filed in court is taken on record.
My lord, actually, what is happening, my lord, my ambulance, the petitioner was unwell. The ambulance could not be entered. My lord, they obstructed in such a way. My lord, what they have done is, my lord, I'll just take a minute, my lord.
Next day, I'll hear you. Yes, next matter. First time.
First time, my lord.
কবে আসছে? 31st? 31st? 31st of July, please serve.
My application appearing for the first time.
Serve.
This matter is pending more than a year, my lord. There were several orders for filing the report of compliance to the alleged contemptor, who is the Pradhan, my lord. Despite this order, my lord, the Pradhan is not coming up with any such compliance order. This is the Pradhan was directed to take legal action against an unauthorized construction, my lord. Despite taking, my lord, any action against such, my lord, unauthorized construction, the Pradhan has passed a post facto, my lord, sanction, and my lord very rightly has.
This matter was heard post facto sanction.
Yes, lord. This
then
matter
it
was
is there in the list.
Yes, my lord, this matter may be placed top of
The
the list.
others are also there.
This is, my lord,
Hmm.
In 251, my lord, we have served, my lord, service is ready, my lord, unauthorized construction matter, my lord. If your lordship, my lord, kindly give it some precedence. My lord. 210 and 251.
210 and
251.
15, 15?
251, 251.
51?
Yes, ma'am.
একটু উপর দিকে তুলে দেবেন তো পরের দিনকে
My lord.
210 210 and 251.
My lord, item 4.
What has happened?
First time appear, my lord.
What? Restoration?
Restoration.
Restoration cannot be done.
Again, madam.